Good evening, ladies and gentlemen. It's time to call this regular meeting of the City of Pasco Code Enforcement Board to order. These proceedings are being presented live tonight on PSC-TV, cable channel 191, and will be rebroadcast throughout the following month. The Code Enforcement Board conducts public meetings to hear issues regarding alleged violations of the city code, in particular property maintenance standards. For those of you present, if you are given the opportunity to address the Code Enforcement Board tonight, we ask you speak clearly into the microphone at the podium. State your name and address for the record, please. If you brought your cell phone, if you would please turn that off. Thank you. We will now have roll call.
Mr. Daniel Gottschalk.
Present.
Mr. Dwayne Van Beek.
Present.
Ms. Mary Gutierrez.
Present.
Mr. James Rawlinson.
Present.
We have 4 members present. We have a quorum.
All right, thank you. Let's stand and do the Pledge of Allegiance. Please, right over here. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you. The next item of business on tonight's agenda is the approval of the minutes from the March 4th, 2021 meeting. May I have a motion to approve the minutes, please?
I move that the minutes of the March 4th, 2021 meeting of the Code Enforcement Board be approved as mailed.
Is there a second?
Second.
I second.
It's been moved and seconded. We accept the minutes as they were mailed. Is there any further discussion? All those in favor say aye.
Aye.
Aye. The motion carries. We will now hear the cases scheduled for tonight, April 1st, 2021 at 7 o'clock for alleged violations of the Pasco Municipal Code. The City of Pasco is a petitioner. Property owners and their authorized representatives here to address the city's charges are the respondents. The purpose of these hearings is to determine whether the city, by a preponderance of the evidence, has proven that the violation charged has occurred upon certain properties owned or controlled by the respondents, and if so, whether the required corrective action is reasonable and whether a monetary penalty is appropriate. The hearing procedure is as follows tonight. First, the chair will open the hearing, which is being recorded. To ensure the accuracy of testimony, each person who will be testifying tonight shall be sworn to truthfulness. Second, the city has a burden of proof and shall present its case, including any witnesses and exhibits that are relevant to the case. The respondent may cross-examine the city and the city's witnesses. Third, the respondent shall present their case, including any witnesses and exhibits that are relevant to the case. The city may cross-examine the respondent's witnesses. Fourth, the city will have the opportunity for rebuttal of the respondent's evidence raised in their case, and the respondent may answer the city's rebuttal. Fifth, after all the evidence is in the record tonight, the hearing will be closed. Remember, this is your only opportunity to present evidence in a case. And then finally, the board members will discuss the charges, facts, and evidence presented. Then we will render a decision. A copy of the decision will be mailed to all parties within 10 working days of this hearing.
Mr. Chair, we're ready to hear tonight's cases. Before we begin, will you please explain the procedure for providing testimony and swearing all city staff, respondents, and any other witnesses who have appeared here to offer testimony?
Sure. Testimony can only be received at the microphone right up here. When you address the board, please state your name and address at the beginning of your testimony. If you have any written materials you'd wish to be considered, please present them to be marked as an exhibit. It will become part of the hearing record. Are there any questions about the procedure tonight, folks, at all? We're good? Okay. Are there any objections that any member of this board hearing your matter due to your belief that any one of us may have a conflict of interest or the appearance of one? And if so, indicate the objection now or it will be considered waived. All right. We will now swear in all witnesses who will testify in these proceedings. Would all city staff, respondents, and witnesses present for any of the cases to be heard tonight, please stand and raise your right hand. Anybody that's going to come up and talk to us, stand and raise your right hand. Okay. Do you promise to tell the truth in these proceedings? If so, please respond, I do.
I do.
Thank you, folks. You may be seated. The city will now present their first case.
Board, if you recall, this first case, CEB 2020-2176, was heard last month, and we continued it because the board wanted an interpretation from council. Tonight we do have one of our city attorneys, Mr. Briggs. So what I would like to do is have Ms. Strader go through the case, and then if Mr. Briggs needs to provide any kind of interpretation, he's here for us tonight. Okay? Okay. So our first case, CEB 2020-2176. Ms. Strader, will you please present your case?
The property known as 618 West Clark Street was inspected on 12/14/2020. Violations of the Pasco Municipal Code were observed and were determined to be repeat violations. A rental inspection was scheduled for 12/14/20 with Mr. Aaron Potts present. The property known as 618 West Clark Street had been recently remodeled and approved as a duplex, units A and B, for 2 single-family dwelling units. Unit A was inspected and it was noted that each of the 5 bedrooms or bedroom doors were individually labeled with numbers 1 through 5. Each room had individual locks that Mr. Potts had keys on hand for, and the office space around the stairs was being slept in, a non-habitable space. During this inspection, Unit B was not inspected due to time constraints, and at the time of the inspection, I assume the owner had obtained a special permit for the rooming house use. After the inspection had been conducted, it was determined that a follow-up inspection would be needed as there was no special permit on file for this location, and it was only to be used as a duplex for 2 single-family dwelling units and not as a rooming house. Mr. Potts was advised of the violations and that he had to either vacate the units or provide lease agreements in order to prove that the unit was only being used as a single-family dwelling unit. Mr. Potts sent a letter advising that he would remove the numbers on the doors of units A and B and would provide lease agreements for the 2 units. A second rental inspection was scheduled for 01/26/2021 for units A and B. Code Officer Rosanna Johnson and Mr. Aaron Potts were present during the inspection. Unit A was noted to have the numbers removed from the individual doors, and the office space around the stairway was no longer being slept in. In Unit B, a house rules note was posted in the laundry room that stated, "All rents should be paid with a money order." It was also noted that most of the rooms had separate individual cooking/food preparation areas and separate entry-exit doors. Each room had individual locks that prevented other tenants who did not have keys or have the keys from entering. Rosanna and I spoke to a couple of the tenants who advised they did not know the other individuals within the unit and had moved in at separate times. One tenant said he had resided at the location for over a year, and another advised they had just moved in. At the time of inspection, I again requested copies of the lease agreements for both units A and B. On 02/03/2021, Mr. Potts' attorney, Ms. Justine Cool, provided 2 lease agreements, one from Unit A and one for B. Both were dated 02/02/2021. Neither had the rent amounts, and they were signed by the tenants with different unit numbers. I asked why the rent amounts were missing and why there were different unit numbers listed. Justine advised on 02/04/2021 that she would contact the property owner and get back to me. Later that day, she sent revised copies of the lease agreements with the rent amounts added and the unit numbers whited out. I advised that I was unable to accept these revisions until they were updated with the tenants' signatures, indicating the tenants were aware of the changes
Ms.
made.
Herschel, let me stop you for just a second. We don't have that second, we only have the first page of that.
It should be on the back of the first page.
I don't think it's there. Let me look again. Nope.
Okay, that's not a problem. We can get that for you in just a matter of minutes.
Board, may I receive a copy of what the city is presenting? I represent Mr. Potts.
Yeah.
Mr. Chair,
They'll
let's
make
just
one
take
for
a 2-minute break. Thank you.
Yes.
Yeah, we're gonna take a 2-minute break. All right, Ms. Strader, if you would go ahead and start at the top of page 2, please.
One tenant said he had resided at the location for over a year, and another advised they had just moved in. At the time of inspection, I again requested copies of the lease agreements for both units A and B. On 02/03/2021, Mr. Potts' attorney, Ms. Justine, provided 2 leases, one for Unit A and one for B. Both were dated 02/02/2021. Neither had the rent amounts, and they were signed by the tenants with different unit numbers. I asked why the rent amounts were missing and why there were different unit numbers listed. Justine advised on 02/04/2021 that she would contact the property owner and get back to me. Later that day, she sent revised copies of the lease agreements with the rent amounts added and the unit numbers whited out. I advised that I was unable to accept these revisions until they were updated with the tenant's signatures indicating the tenants were aware of the changes made. On this date, I continued the code case from the code board hearing scheduled for 02/04/2021 to 03/04/2021 to give Mr. Aaron Potts additional time to provide the lease agreements. On 02/05/2021, a third copy of the 2 leases were provided with the updated information and the tenant's initials signatures next to the revisions. Previous notices were sent on the following dates: 09/11/2019 for code case CEB 2019-0982 due to failure to provide correct number of dwelling units on rental license application, business number 33386, only approved for units A and B upstairs. A repeat notice of civil violations was issued on 12/15/2021 or 2020 via property posted. The property owner was legally notified on 12/15/2020 of the conditions which I believe to be repeat violations of the Pasco Municipal Code. Based on the final inspection of the property, which was completed on 02/05/2021, it is my opinion that the property is not in compliance at this time. The City of Pasco recommends that AAA Renovation and Construction shall pay an immediate monetary penalty of $200 for failure to maintain the property free of the same violations during their period of abeyance on prior code case CEB 2019-0982 and pay $200 for a repeat penalty for case CEB 2020-2176. Be given 10 days to correct any remaining violations or pay a penalty of $200 per day for 10 days.
All right, thank you. Who'd like to be heard in this case?
I
Come
still
on
have the presentation as well. Sorry.
Oh,
Sorry.
okay, go ahead.
Okay, so the details of the case are as follows. The violations were the PMC 5570, failure to provide correct number of dwelling units on a rental application for license number 33386. License was only approved for duplex and not as a rooming house. The PMC 2560-020, conversion of property from duplex to rooming house does not follow zoning standards for R2 zone. And then IPMC 404.4.4, upstairs office space around stairs in Unit A is a non-habitable space and must be vacated. The resolution at this time is that the violations have not been corrected. This is a copy of the upstairs floor plan. As you can see, it's indicated down below as Units A and Unit B. Same with the downstairs floor plan. It's supposed to be Units A and Unit B. The letter that Mr. Potts sent us is read as pursuant to your January 9, 2021 email to our attorney regarding the above referenced case. I am writing to acknowledge the following with regard to our rental property located at 618 West Clark Street, Units A and B, Pasco, Washington. The numbers, letters on the doors of Units A and B, other than for purposes of postal delivery and emergency address identification, will be removed from the premises, and residential rental units A and B thereof shall be separately rented as single-family units, each under separate lease agreements. So the copy of the first lease agreement that we received for Unit A, as you can see, is missing the rent amount and The units for each of the tenants was individually labeled A2, A3, A4, and so on. Same for the first copy for Unit B. The rent amount was missing, and the unit numbers were labeled 5B, 3B, 2B, and so on. And then once we questioned Mr. Potts' attorney regarding this indiscrepancy between the unit numbers and the missing rent amounts, she sent us a revised copy of the lease agreement for Units A. The revised version had the rental amount put in the line, and the unit numbers, as you can see, were whited out. And that is the same for the revised copy for Unit B. The rent amount was installed here, and the unit numbers were whited out as well. When we advised that we would not accept this, because the corrections were made after the tenants had signed the forms, they sent us a final copy of the lease agreement for Units A and B with the tenants' signatures added to the corrections. And based on all of this information with the individual keyed locks and the unit numbers and the individual kitchen food prep areas, and the lease agreement, the city decided that the rooming house use was valid and our assumptions were valid. So when we went in, we saw that there were, in the laundry room of Unit B, there was a house rules that indicated all rents should be paid with a money order, which further indicated to us that there are multiple rents being paid for this one supposed unit. This is a photo of the downstairs of Unit B on the left-hand side. The door, as you can see, has an individual keyed lock that one tenant would have a key for. The room had this kitchen space, a full kitchen with oven, refrigerator, as well as a separate entry-exit door. And around the corner there was a bedroom with a full bathroom, which further indicated to us that this area was separate from the rest of Unit B and other tenants would not have access to it. This is the photo for the non-habitable space that was being slept in. And then further kitchens and dining spaces. And another room with a food prep area. This is the prior case, CEB 2019-0982. The details for this case, the violations were as follows: the PMC 5570, failure to provide correct number of dwelling units on rental application for license number 33386. License was only approved for units A and B upstairs. PMC 2560-53, conversion of downstairs building to multiple units in violation of density standards for R2 zone property. The resolution for this case was that the violations had been corrected and the repeat penalty of $200 was held in abeyance for 2 years. During that case, the code officer had contact with Mr. Potts, in which he explained that his purpose for the property was that he, as you can see in red, it says he stated that the left and center units were meant to be one, and he had planned to rent them out as separate rooms within one unit. However, there are 2 separate kitchens in that area, and he was advised that the separating doors at the laundry area and one of the kitchens would need to be removed in order to restore it to a single unit. The code officer explained that the use he had described would be considered either 2 separate units or a rooming house, neither of which were going to be approved for the location. This shows that the intent, even at the beginning, was for him to have a rooming house. These are the photos from that case. As you can see, the unit numbers are labeled above. And there were 5 mailboxes.
All right, thank you very much. Sir, if you'd come up and state your name and address for the record, please.
Hey, please, the board, my name is Brian Davis. I am an attorney at Levy Schultz Davis, located at 2415 West Falls Avenue in Kennewick, Washington, 99336. I represent Mr. Anthony Potts in this matter. And I guess by way of clarification, I certainly don't want to overstep my boundaries in regards to the procedure here. I will admit this is my first time presenting before this body, and so I appreciate your leniency if I do step out of the procedural rules. I would like to begin with a brief opening before I cross-examine the city's witnesses, if that's
Okay, well,
appropriate.
here's what happened last time, if I recall properly, is that the city thought that they were referring to it as a rooming house, correct?
That's
And
my
Mr.
understanding.
Potts, were you the attorney we talked to on the phone?
No, Miss Justine Cayley was,
it
but
was
she is,
Justine. I thought she did quite well, actually.
well, she's very talented, but
Yes.
she has gone on to greener pastures.
Okay,
So
that's-
unfortunately,
okay.
my caseload has gone up and she's left.
Excellent, excellent. Well, what I meant is that she did present the case well, and so she thought that it didn't fall into the rooming house description. And so, go ahead and tell us, what do you like to now?
Well, I certainly don't want to be duplicative, and I apologize because I was not here when Ms. Cayley gave her presentation. But I would like to start off by addressing a couple of issues.
Yeah?
We are dealing with two issues, whether this is or constitutes room housing. And I think in order to determine that, we have to look at the code. We have to look at what the code says in terms of what is room housing. And we cannot rely on assumptions. Code enforcement's job is to enforce codes, not to create and start new codes. And I will represent to you that there is no code in the Pasco Municipal Code that says you can't have a lock on your door. I have an au pair who helps us watch our kids. She has a lock on her door. There's no code that says, hey, I'm the government. I get to come into your house and say, get that lock off your door. Otherwise, you're gonna have to pay money, because that constitutes, based on my assumption, room housing. There is no code whatsoever. You'll not find it that says someone cannot designate their specific space by way of name, nameplate, letter, number, poster, color, or anything. There's no code that says you cannot do that. Okay? And the only code that we can find that tells us whether or not this is not a single family dwelling is the definition of family. That's the only thing that we can look at. And by the way, I'd like to say many of the things that they've presented have been corrected. Okay? And what our law firm did when this started is we went and we reached out to the city and we tried to rely upon the city to cooperate with the city to see what we can do to get this resolved. Okay? I have exhibits. May I approach? I used to teach for 10 years. Can I give you the old take one and pass it down?
Yeah, start over there if you would,
I don't know if I have enough time.
or just, how do we want to do that?
I don't know if I have enough.
Start with the lawyer.
Okay. Okay. Thank you, sir.
Thank you.
It's our position that the first issue that we are dealing with should not be at issue at all, because we worked with the city and we tried to comply with exactly what the city did. What we did is we went, Ms. Cayley, if you start at the very end of the email, reached out to Mr. Hendren and said, hey, listen, here's our position on these code violations that you're citing, okay? And she supported it with law. She supported it with what the code said. And I'd like to point out that under Pasco Municipal Code 25.60.020, she said, listen, family is defined as one or more persons, but not more than 6 unrelated persons. living together in a single housekeeping unit. And as it currently stands, that's what it is on both units. You have 6 people on one, you have 5 people on the other. Okay? They're unrelated. And that is the definition of family. If you go to the very first page, when we brought this to the attention to Mr. Hendren, he responded, see below definition of a single housekeeping unit, Law Insider Dictionary. And he says, well, a single housekeeping unit means something different. And so now we have enforcement of a code, but not reliance of the very definition as outlined in the code. And he cites a single housekeeping unit. I went to the website today, and I'd like to present what I found at the website. And this is what a code enforcer is relying upon to enforce a code. LegalInsider.com.
Okay.
I believe I have just enough.
Okay, thank you.
Yes, sir. Code enforcement is here to enforce codes, not to create codes. Ms. Cayley cited what the code was for the definition of family, which will thereby make this a single-family dwelling. Mr. Hendren responded to a website, says, well, here's the definition I'm going to use. I'm going to use the definition that's on this website. If you look at that website, legalinsider.com, it gives you 3 different definitions. Mr. Hendren had a chance to pick and choose which definition was going to best suit his argument. Well, that's not the definition as passed by our lawmakers, elected lawmakers, city council board members, who pass law and they are codified in the Pasco Municipal Code. And that's the codes that need to be enforced, not codes that are brought out of the Google search of legalinsider.com. And so we explained to Mr. Hendren, listen, a single family dwelling constitutes 6 unrelated people living in one unit. And that's what we have in this situation. There's no code that says you can't have a lock on the door. There's no code that says you can't designate what your door looks like. There's no code that says any of that. There's no code. You will find no code, members of this board, that says you cannot post up a message saying, here's the rules of the rent. There's no code that says you have to have one lease agreement with everybody. I went to Washington State University. I joined a fraternity and survived, thankfully. Now, when I moved out, I lived with 5 different people. And you know what I was required to do? Sign a separate lease than my other people in that one single-family dwelling. And the reason is because some people were going to graduate at the end of the semester. Some people were going to have to stay for another year. Some people had larger rooms with better amenities, and they paid differently. There is not a single law in the state of Washington that says, go read the Landlord-Tenant Act. There's not a code that says, landlords, you have, if you're going to follow this single-family dwelling, you're going to have 6 people unrelated live there. Each one of them has to sign a separate lease. That is not the law. That's just not the law. The government doesn't have that power. So as we continued down, we were requesting an opportunity to work with the city to come into compliance. Mr. Hendren said at the bottom of the legalinsider.com definition, I would accept removal of the door numbers or letters and a letter acknowledgement from Mr. Potts indicating units A and B will be rented or used, not rented or used as room housing, will be rented to a single family unit under a single lease agreement. We said, that's great. Let's do it. Let's work with the city. That's great. So we did it. Then we asked for a code, but it wasn't provided. But upon further research, we could not find that there was any code that said separate lease agreements were required. We just couldn't find it, and it wasn't provided. And then under Pasco Municipal Code 5.05.070 violation, we're like, well, single A is a single family dwelling unit as defined pursuant to the code. It provides complete housekeeping facilities for one family and qualifies as a singular dwelling unit for purposes of Title 25. Each individual bedroom does not provide complete housekeeping facilities and does not qualify as a dwelling unit. We should not have to change the number of units in its business license. Well, first of all, this is an interesting violation because they're taking the position that we cannot have 6 different dwelling units here, yet they're taking the position that we have to change it to comply to that, which doesn't make too much sense to me. But Mr. Hendren responded, and I will attest to you that Mr. Hendren does a good job. I've worked with him in the past, and he has worked with people in the past, and I believe that to be true. And here is a perfect statement. It says, this may be a misunderstanding. It can't change the number of units for this property. To come into compliance with this requirement would be to provide the letter of acknowledgement as previously discussed. The property cannot be used as room housing. I agree with that. It makes no sense to say, hey, you're violating the code because you're not illegally listing it, pursuant to my prior argument. It doesn't make sense. And here he said, just provide us a letter, provide us those leases, and we'll do it. And I'd like to talk about those leases. These leases were drafted by my office, sent to our clients, and forwarded on to his tenants to say, please fill it out. These tenants aren't necessarily sophisticated people, and they listed it the way they perceived it. Okay? Now, I have these agreements I'd like to pass out to you. I don't know if you have them. I know we have some. I don't know if you know that Mr. Briggs was my student back in the day.
I think we spoke at my graduation.
I hope I did a good job.
How about that?
It is a small world, isn't it?
It is a very small world. I taught for 10 years and I left 13 years ago, and I wonder why. Because nobody likes a lawyer necessarily, but everybody likes a good teacher. You're welcome, thank you. And I would have provided these in
Thank you.
advance, but I understand this is our first open meeting.
Yep.
We'll go back.
Yeah, it's nice to see people in person.
Oh, boy, I tell you what, I was just talking to Rochelle actually this afternoon, saying people interaction
you.
is unhealthy if you don't have it.
Oh, yeah.
Thank you.
There we go. There's the second one. This is exactly what Mr. Henders requested us to do. Now, did it go smoothly? No, it didn't go smoothly. I'll agree with that. It didn't go smoothly because there was a different perception, but we did it, we got it done. And I would have you go to the front of the page, and please note, there's no more than 6 unrelated people on these leases. There are no more than 6 unrelated people on these leases. And if you go to the very back page, or actually all throughout the documents, these people all executed this correction. They all executed with their own signature. And in our society, we use our signature to attest to something, to affirm something as if it is true. And they attested to that. Yes, there was a mistake. I talked to my client about it today. He laughed and said, yeah, that made this matter a lot worse. It did. But they attested to this, and this is exactly what Mr. Hendred did. And Miss Sadler, is it Sadler? I don't want to... Strader, I apologize. I don't want to get your name wrong. And Miss Strader said that she wouldn't accept it until this was done. Well, it was done, and it was accepted. Okay? Now, so we removed the letters. We got everybody to sign a lease. And then the letter. My client sent a letter just as requested to come into compliance, saying he did exactly these things. And so I think the city should be what's called equitably estopped from even bringing this point in the first place. Equitable estoppel is a legal doctrine. It says that when one person takes one position and another person relies to it to their detriment, they cannot all of a sudden change their position to the harm of the one person who relied upon it. Said otherwise, my client contacted the city through Troy Hendricks, was given instructions as to what to do to come into compliance, and did exactly that. Did exactly that. But now, the city has taken a different position. This evening, I contacted Ms. Strader. I said, Ms. Strader, I just want this to be an efficient process. Are we arguing this situation? Because my understanding, based on the reliance of my client to do everything that the city asked him to do, this matter should be concluded. She told me, Brian, you put that question in writing. That's fine. I sent her an email. I said, here's my understanding. The same understanding that I just explained to you. We did everything that he said. And she came back and said, no, it's still an issue. Even though today she testified that she accepted the second document, she's now taking the position that because the first document had those letters, no, still an issue. So we relied on the city's assertions to do what we're supposed to do. We did what the city asked us to do. And I even said, Rochelle, hey, please, look, Here's what Mr. Hendren did. I cut and pasted the document we just talked about, our reliance upon his instructions. And I even then attached the letter, which I just handed out to you, from my client, saying, we did what you wanted to do. We did what you wanted to do. So I don't necessarily think this first issue should be an issue at all. But we don't even need to get that far, because this is a matter of code interpretation, strict code interpretation. Can you please go back to the plan for this? Okay. Is this the lower level or is this the upper level?
That's the upper.
Thank you. Can you go to the, so everything on the bottom exits to the outside, is that correct?
Not every door. Most of them do though.
Okay. And is this the bottom part of it?
Yeah, that's the downstairs portion.
Okay, and these doors too, most of these doors exit to the outside, is that right?
Correct.
Okay. Can you please go to the picture that shows that kitchen? Compare that picture and tell me where that picture is located on this map.
So the kitchen is in the downstairs. If you look on Unit B on this photo here, let's see, oh, that is a pointer. Okay. Maybe, I don't know how to make it work though.
I would say that it's probably, if I may, my
It's-
assumption is, so I start reading this plan, is it would be located here.
Yeah, it's right
Here's
on
the
this.
door. And this is designated as kitchen dining area.
Mhm.
And then we have a bedroom that has a bathroom and toilet. There's no code that says you can't have a bathroom in your bedroom. There's no code that says you can't have a mini fridge either. There's no code that says you can't even have maybe a coffee maker. You can have those things. But this, which was approved by the city, okay, this is a building permit approved by the city, shows this kitchen and dining area. Now, can you please go to the picture of the kitchen and dining area? Because I want to make sure we were very, very clear that we represented this board, this body, making this decision, that this is not in the bedroom. This is not housekeeping stuff that's in the bedroom. Here's the door, and it goes outside. This is the kitchen area. This is a misrepresentation of what's going on.
Sir, can I have you go back to the podium?
Yes. I just wanted to make sure I pointed out to the board so they understood what I was.
I understand. You just can't, you're not heard very well.
Oh, I apologize. That's a problem I don't normally have. Okay, thank you very much. I just wanted to clarify that. Can you go back to the plans? So as we have in these plans, I'll try this. I'm just gonna move to reading them. Oh wait, I got it right here. My pinch and zoom on this? No. If you go to these plans, it has designated kitchen and living areas. That's what it has. Okay? And this was all approved by the city. There was a lot of discussion about the prior issue. It's not illegal for my client to have an intent to lease out rooms or sublease rooms. That's not illegal. You just have to be defined that it is a family to be a family dwelling. Can you please go to the area that highlighted the dialogue, the slide that highlighted the dialogue between Mr. Hinder and my client?
Sir, you're looking for one that was highlighted?
Yeah, there was a red portion of my client stated was highlighted in red. Here. I haven't seen these, so I'd like to have a chance to read it in its entirety. Is this a dialogue between Mr. Hendren and Ms. Strader?
No, this is from the previous case between Rosanna Johnson and Troy and Aaron.
So Troy, let me ask you a few questions just to clear up the facts, because I just jumped into this file a little bit, so forgive me if I'm confused. But as I understand it, originally my clients wanted to build a fourplex in this unit. Is that correct?
No, he wanted to create a rooming house for Department of Corrections. He had a lease agreement with the Department of Corrections to kind of use it as a halfway house.
Gotcha. But there was a point where my client sought to create, and did in fact create a fourplex, and then that was held to be in violation. Is that your understanding?
I don't recall if it was ever a fourplex. All I recall is a duplex.
I'm sorry to interrupt.
Uh-huh.
My client is of the position that at first he created a fourplex, and then when this happened, he had to create stairs. If you recall, he had to build stairs
Yes.
to connect the two and then make it a duplex.
Correct, with a firewall, yes.
Okay.
Because that's what it's zoned as,
That's
is
right.
for duplex only.
And he did all that, if you can recall. Once he was
Yep.
like, you can't have fourplex, even though he took a dilapidated building that was completely vacant. It was Blythe in downtown Pasco. I'm a bulldog. I love Clark Street. And he put a lot of money into it, made it a fourplex. And when he told he couldn't do that, he then expended more resources to make it a duplex. Is that what you're
Correct,
saying?
2 single families, yes.
Okay. So he complied with that. And here, it appears that you explained that you cannot do any rooming house. Is that clear? Right here it says, described would be considered 2 separate units or a rooming house. I
Yeah.
explained that the use had to be described, he had described would be considered 2 separate units or a rooming house, neither of which were going to be approved by the location. Is that your recollection of the conversation?
Yes,
Is it also true, your recollection of the conversation, that he agreed? And then he submitted plans that we just reviewed.
corrected it, yes.
So he complied to that as well.
Yes.
Mr. Hendren, is it common that people work with you and follow your guidance in order to become compliant with the city?
Absolutely, daily.
And I'm sure you do. I know you work with individuals. Like I said, I had a case with you a long time ago. It was a nightmare. But and when you told Mr. Potts this and gave him these instructions, did you have an expectation that he would have to follow those instructions in order to be compliant?
Yes,
And he did follow those instructions, didn't he?
he did, yes.
Yep. Ms. Strader, do you know the definition of room housing pursuant to the Pasco Municipal Code?
Yes, I do.
Can you please say the definition of room housing for the board?
A rooming house is a building arranged or occupied for lodging with or without meals for compensation and not occupied as a 1 or 2 family dwelling.
Okay, not occupied as a 1 or 2 family dwelling. Thank you. Pursuant to the Pasco Municipal Code, okay? Unit A is a single dwelling unit pursuant to the definition of PMC 25.15.060. Unit A provides a complete housekeeping facility in a separate designated area for 1 family and qualifies as a singular dwelling unit for purposes of Title 25. Each individual bedroom does not provide a complete housekeeping facility. A complete housekeeping facility is a stove, a refrigerator, a sink, all the things that you would see in order, complete plumbing, okay? Separate electrical boxes. That doesn't exist here. It doesn't exist here. Can you please go back to the slide one more? And any representation that this is in someone's room is completely false. Each individual room, let's see, now, under PMC 25.15.060, a dwelling unit means a building or portion thereof providing complete housekeeping facilities for 1 family, okay? That's what a dwelling unit is. A family, pursuant to PMC 25.15.080, is, it means 1 or more persons, but not more than 6 unrelated persons living together as a single housekeeping unit. one but not more than 6 unrelated people. That's what we have here, members of the board. They're not related. And by the definition, that's the code. By the definition, that means family. And by the definition of a dwelling unit, we're providing housekeeping facilities for one family. That's plain and simple. We do not satisfy the definition as just read. This is not a boarding house. This is not room housing. There is no code that says you have to have separate leases for everybody that lives in a unit. There's no code. And to reach otherwise and force someone to do so is an abuse of power. There is no code that says you can't have any locks on these doors. Otherwise, I'm going to come find you because it's going to make it look like an assumption that you're doing something. Okay? There's no code that says you can't do that. There's no code that says you have to collect rent from everybody at once in one simple manner. There's no code that says you have to do that. And to force someone to say, yeah, you do, otherwise I'm going to ding you with this, is an overreach of power. The code is the code. The definitions are the definitions. Plain and simple. Issue number 1 is a non-issue because we're in compliance based on the instructions of Mr. Hendren, who just testified that he expects people, and they do all the time, rely on his instructions to become compliant. And to now go back and change our license to reflect something that it's not, because you have 2 single-family dwellings, would not only contradict the code, it would be pointless because we're in compliance. I am hopeful as we move forward that my client and the city can continue to work together. Sometimes in my experience, I see that the city and particular individuals can get crosshaired, and that's upsetting, especially when you have individuals who want to invest in infrastructure, they want to invest in property, and when they do, they put substantial sums of money in buildings like this one to help a community. I look at this and I feel that perhaps the city has, and my client perhaps have gotten off to the wrong foot. And it's my job to make sure that we continue to work together because it's good for the city. It's good for the city. But to put this on my client when it's not supported by the code is a complete overreach, especially when we relied on the instructions to become compliant.
Mr. Davis, can we have Mr. Briggs respond, and then you'll get a chance to respond after him if you would like?
Absolutely. Thank you.
Okay.
I appreciate your attention and time.
You bet. Go ahead, Mr. Briggs.
Thank you. And I agree with Mr. Davis that, freedom of property owners to use the property as they see fit is an important fundamental property right of the owners. But sort of overlaying that is the, police power of the state to regulate the health, safety, and welfare of its residents. And the fact of the matter is that, something that might be appropriate in one area, like a gas station or whatever, might not be appropriate in an area with, single-family residences. So the issue here is whether, this duplex is being operated as 2 single-family residences or as a collection of rooms that are being rented out by individual tenants. And this really turns on the definitions that are found in the code, as Mr. Davis has pointed out here. But a family, by definition, must occupy a single housekeeping unit. A housekeeping unit is a room or group of rooms forming a single habitable space, equipped and intended to be used for living, sleeping, cooking, and eating. A habitable space is a space in a structure for living, sleeping, eating, or cooking. Bathrooms, toilets, closets, halls, and storage and utility spaces are not included in that. So the real question here, what this case turns on, is whether we have a habitable space or habitable spaces, right, in plural. And the initial lease that was provided by the landlord is very telling here. That signature line for the tenants that had, B1, B2, B3, B4. This is designating each individual tenant's habitable space, right, that they are renting out. And that is not appropriate in a single-family residence. It might be appropriate in a hotel or a rooming house or some other facility like that. It is just not appropriate for the character of that type of neighborhood. Now, a rooming house, as we all agree on, is a building arranged or occupied for lodging. Unfortunately, lodging is not defined. But the dictionary definition of lodging is a room or rooms rented out to someone. That's what we have here. We have a rooming house. We have rooms rented out to individuals. They don't know each other. They enter into these leases at separate junctures, and for separate reasons. They come and go for separate reasons, and there's important reasons to keep track of these types of businesses. We have to worry about human trafficking, registration of sex offenders, things like that. So there's public health and safety concerns that the city should be keeping in mind, and under its police power, this is a valid use of that. This is really multiple contracts disguised as one contract. And as Mr. Davis pointed out, the city asked them for a lease, and what did he say? So we did it. They went and created this lease after the fact to make it look like all of these tenants are living under the same lease. There's a deposit in that lease agreement, but under the Residential Landlord Tenant Act, deposits have to be accounted for. There has to be a checklist and so on and so forth. That wasn't provided with the lease agreement, and I don't think that it could be, because these tenants, again, moved in at separate times when the deposits were given. They were probably had different walkthroughs, and so this is sort of a post hoc rationalization to try and make this a single family residence. There's the locks on the doors. Again, not illegal, but indicative of the fact that these are separate tenants renting out rooms, sharing these living areas. So that's really, I didn't have as much. I mean, Brian just really, he's
good.
He and I mean, we went to, he was a really good teacher, but we don't always agree on things. And I think really this turns on, what is a housekeeping unit, right? And the definition there, is this a single habitable space? It doesn't sound like it to me. It sounds like the individual tenants are renting out rooms, and these are each their own individual housekeeping units, their own individual spaces that they take care of. They can exclude the other tenants. I mean, you can exclude a roommate, sure, but when you sign up for a lease with a group of other tenants, typically, as a fraternity or something like that, it isn't drawn up like that, right? You don't rent out an individual room. This is indicative of a rooming house, and for that reason, we would ask that you uphold the, Code Enforcement Hearing Board's rationale on this.
Okay, Mr. Davis, go ahead.
Yeah, first and foremost, for the record, I want to thank you, Mr. Briggs, for your kind words. It's very sweet of you to say, and it's okay. Attorneys tend to disagree all the time. Unfortunately, that's the nature of our business. But thank you. I appreciate you saying that about my educational career. Now you got me blushing and lost my train of thought. But I object. Sorry. I object to a lot of what you said. First of all, it misstates the evidence, and it's not even before this court. There's no allegations of sex trafficking that's being supported by my client. The fact of the matter is protecting the safety and the community is important, but I think it's important to look at what my client did with a building that was completely vacant in downtown Pasco. He brought it back to life, and now is providing an opportunity for people to live in a single-family dwelling. Can you please bring up the plans again? I want to point out to the board that these plans were approved by the city. They were submitted to the city. They were approved by the city. And in nowhere in these plans, in one bedroom, do you see a bathroom. Maybe in some you do, but not in all of them. In these bedrooms, you don't see a kitchen. There's no plumbing to a kitchen. There's no electrical box to each one of these. There's just not there. It's just not there. Instead, what you do see is they have communal dining areas. They even have a communal dining room table set up. That's indicative of a single family unit. They have, yes, please.
If it's communal, to me, it's that you're sharing it with somebody else.
That's right. That's right.
So to me, and I'm not a lawyer, but to me, it's that it's being rented out as a boarding house or whatever we want to call it.
Well, I appreciate that statement, and I'd like to clarify a few points, okay? We have to look at the definition, okay? If we're going a boarding house, or if we're doing a room sharing, and we're not, at issue before this board is not a boarding house. That is not at issue. So let's keep in mind what is at issue before the board. The issue before the board is room housing, okay? And room housing, by the definition, means that every one of these rooms comes complete with housekeeping facilities. In order for us to get into that legal definition that they want to cite my client for, each one of these rooms has to be complete with housekeeping facilities. But that is opposite. That's not what we have. We have areas that are shared. We have dining rooms. This isn't a facade. If he was truly going to do this, make that into a bedroom. Make that dining room into a bedroom and then pull the wool over the eyes of the city. But instead, he went to the city with building plans. He got those approved. And now what my client's doing is he's renting to 6 strangers that have their personal property in the room and want to keep it safe from other people. 6 people who come and they use that stove. They have house rules. Go back to the house rules, please. I didn't get a chance to see those. Be respectful of others. Please clean up after yourself immediately. That's indicative of people using spaces that other people use. Clean up after yourself. That's evidence of them not staying in their own housekeeping facilities, but as you said, Ms. Gutierrez, sharing space. That's evidence of sharing space. No smoking on the property. Laundry. Do not leave clothes in the washer or dryer. Only do laundry when you're here. That's indicative of people sharing laundry. Yes, Mr. Rawlinson.
I have a question on number 6. All rents shall be paid with a money order.
Sure.
Is each individual tenant paying rent to the property owner?
They are. They're not living for free, that's for certain. Yes, they are.
So that's 5 different people paying rent
Sure.
on a single family unit.
That's right.
Doesn't make sense.
Well, when I was in college, that's what we did. When I was in college, that's what we did. My roommate had a great room. He had a walk-in bathroom, and he paid more for it. I lived in the basement. I paid less for it. I made that choice because I didn't have a lot of money. And that was okay. There's no code that says that's how you can structure. The law of contract says you can contract with anybody any way you want.
Mr. Davis,
Yes,
when you were in college, though, I would assume that was in a zone that allowed for rooming houses, for boarding houses that were weekly and monthly.
I don't know the answer to that. I don't know the answer to that.
This area is zoned where that could be a duplex, which is 2 single families. That's why we required Mr. Potts to do that firewall down the middle.
And if I may, I appreciate your line of questioning, but I don't know if it's appropriate right here, but I do appreciate it. I don't know what the zoning regulations were for Pullman, Washington. But I do know what the zoning regulations are for the city of Pasco. And I also know what the definitions are with the city of Pasco. And I know that there is no definition that says you can't contract with your tenants and force them to pay in any manner they want. They can pay with Bitcoin if they wanted to. They can pay you can pay with an automatic deposit, you can pay with a money order, you can pay with cash, you can pay with check. People, when they contract, can organize their contracts any way they want. What's the last one say? Please clean off the lint trap after every load. Again, they're sharing these things. So you have a building plan that was submitted with a one universal communal kitchen, a dining room area, and separate bedrooms. And you're leasing to 6 individuals who are unrelated. That's all within the code.
Okay. And the picture that you show of the kitchen has a lock on the door?
These are not my pictures. Let's go look at it. These are the first time I've seen this evidence from the city. It looks like there's a deadbolt on the door, and it looks like that goes outside, which would make sense. And this also goes outside because there's an air conditioner unit there.
Well, my question, though, is, so to get into this room, the tenants have to leave the interior of the building to access that room?
Well, I'd have to go look at the plans. I don't know if that's necessarily correct. Can we go back to the plans?
So on the upper left-hand corner, you see that there's a door handle with a keyed lock. That door is at the bottom of the stairwell, and that door leads to this kitchen area that is locked off from the rest of the unit. The room is on the other side of this kitchen area with the bathroom, and then we have the entry-exit door there.
Could we go to the plans? Yeah. I think that'd be helpful.
So the the lower right-hand corner here, the stairs, they ended up getting revised and they actually go straight down. But they go straight down, and on this corner right here, I don't know if you can see it, that is where that locked door is at, where the key locked. And then that's how you enter this kitchen area and have the entry-exit door, as you can see.
My question is that there's 5 units on the bottom level being served by that one kitchen area?
No, this is divided from Unit A and Unit B. The division line is that dotted line that you see right here. Goes straight down.
Is there a kitchen for each Unit A and Unit B, or is it just one?
There's a kitchen on the Unit A side. There's one in the upstairs and downstairs, and there's also a kitchen in the upstairs and downstairs of Unit B.
Okay.
And
can they be accessed without having to go to the exterior of the building?
if they have a key for at least Unit B, if they have a key to that downstairs door, then they can access that kitchen.
Okay, how about Unit A?
Unit A, I believe that was straight open on that one.
It's open to everybody?
On that one, yeah.
Just to clarify, can you, and I don't know, I haven't seen the place, so are you suggesting that the living room and then the stairs and then the kitchen dining, there's that door we saw in the picture is located right there?
Correct. And that living room that you see that's labeled living room right there, that is where there's actually a bed.
Okay.
And a locked door.
I just want to be clear. You're stating that the picture we saw is the door right here with that lock.
Correct.
Can you go back to that picture? And to be clear, this is outside, right?
Yeah, that's
okay,
exterior.
Can you go back to that picture?
Yeah. So where I'm standing, the door is behind me.
Okay. But the picture of the door I'm seeing goes outside.
That's the second door. So we have that door right there, and then the picture on the left is the door that's behind me.
And you're not aware if each one of these tenants has a key to that door?
I don't know. Yeah.
If they're going to use that, they would have to have a key.
Absolutely.
Yeah. And so they have a key. And go back to the plan real quick. If you So we have a bedroom that goes open up to this dining room. You have stairs that have more bedrooms up here that have access to this dining room. And you have stairs that have more bedrooms up here that have access to this separate living room as well.
That's not correct. That living room space that you're pointing at also has a door that's locked right in the end of the stairwell.
So,
that has another area that has a bed.
there's a bed in this room?
Correct.
Can you go to that picture, please?
I don't have it.
You don't have a picture.
Not on the slide, no.
Well, I'd have to disagree with you because that's not my understanding. Okay. Now, this does have access to this bedroom too, correct?
Correct.
There's no kitchen in that bedroom?
Correct.
No kitchen in this bedroom?
Sure.
So they have access to those rooms. Let's go look at the house rules themselves. They're asking people to clean up after themselves in the shared areas.
Right.
It's within code. I appreciate your time.
Right.
And thank you, the city, for your work, and thank you, Mr. Briggs.
All right, thank you very much.
May
There being
I
no
respond briefly?
Oh, yes, Mr. Briggs. go ahead.
Just,
That's fine. If I may, though, I would
Yep.
request rebuttal.
Yeah, absolutely.
Okay. Burden of proof in this matter.
right.
Absolutely.
I just wanted to point out again that the family definition has to occupy, a single housekeeping unit, which is a single habitable space. But the definition of habitable space is a space for living, sleeping, or cooking, right? A single space for all those things. It excludes bathrooms, toilets, closets, halls, so all that stuff doesn't matter. Bathrooms, toilets, all that stuff isn't considered part of the habitable space. So it's really, is there a single space, you know, that all the tenants occupy with respect to their living quarters, their bedrooms? And clearly here, they're being rented out separately. That's all I have.
I agree everything right there, except being rented out separately. I mean, they're paying on separate notes, or they're paying separate prices, but that's not illegal. I would agree, though. And you have exactly what that is. Everybody has access to those things, and just go look at the house rules.
Yeah.
Those are house rules made by the tenants. Please clean up after yourself. Do your dishes. That's not made up. That's by those tenants. That's
Yeah.
their actions. Yes, sir. Well, that is a good question. It could be for a number of reasons, I don't know. It could be because perhaps when they were installed, it was just, they were installed with extra doorknobs that had locks. I don't know. I don't even know if the locks are functional. But, you know, that's an excellent inquiry. And if this board wants to inquire further and put this out, that would be a reasonable thing to do. We can line up all the tenants if we have to, get their testimony. I don't think we need to, because number one, I think this is a non-issue. I think they're equitably stopped from bringing this issue because we did everything Mr. Hendren told us to do, but we're still discussing it here. And number two is non-issue too, because why would we change that when we have a city-approved building design and plan that was provided a certificate of occupancy that is built like this for 2 units, which is what our license says. But excellent inquiry.
I have a question for the city. So if it was approved for a unit, for a duplex as a family.
A duplex is 2 single families.
2 single families?
Yes.
Yes, because way in my early ages, I lived in a duplex.
Mhm.
I lived in one and another family lived in another.
Yes, ma'am.
So, when they did the plans, it was for the duplex,
Yes, ma'am.
correct? So
2 single families.
2 single families.
Yes.
And so, we've gone through this before, so what the city is going by, and I appreciate the lawyer, but it's like, in my mind, it's still a duplex. 2 single families, and each one is charging. And I get the definition of family, but to me, it's like, if it's a family, why are we all paying differently?
Well,
And that's where I'm totally.
we're gonna talk about that in a minute, okay? Mr. Briggs, you wanna say something else? Was it?
No,
Oh, okay, Dwayne, go ahead, sir.
the drawing on the screen is a little small for me to clearly see. So I'm looking at the floor plans that were presented to us in our book, and which I believe are representative. I don't see anything that's not the same as. And the first phase, it says Unit A on the left and Unit B on the right. And as we look at that, and you see the 2-hour firewall that is there. Now I look at that first one, I would assume am I assuming correctly that that's the ground floor? The bedrooms are on the second floor? Is that
It's a very odd building. I think we all can kind of agree that it's the basement is subterranean, but it's like a daylight basement.
okay?
It's just kind of an odd shaped building.
I'm just trying to make sure I'm looking at the right place. That the first page here is, we'll call ground floor. Is that a fair statement? The one that says Unit A on the left, Unit B, because my drawing doesn't say upstairs or downstairs.
Let's see here. Living area 1900 square feet. Administrator, can you go to the main floor, and then Mr. Van Beek can
It's
cross-reference.
It's the one that shows what I'm looking at, Unit A. If I go across the top, midline, I see a double set of doors to the outside, and
Yes.
I see
That
then
is
a
the main
bedroom
floor.
and a bath.
Correct. That is the main floor.
Okay.
You're actually looking at the main floor right now.
Okay, and then I see the 2-hour firewall, correct?
Yes.
And then there's the stairway. Now, is the door you're talking about, is that at that junction of the stairway and the hallway? Because that, if I'm looking at this correctly, the living area on that level is wide open, is open to the hallway, is that correct? If that's what this drawing is?
Yes, sir.
According to the drawing, yeah.
Yes.
Okay, and then the other two rooms to the left are unlabeled, so I'm not sure what they are. When I go to the right then of the duplex area, starting again at that 2-hour wall at the upper portion of center line, I see a bath, a bedroom, a bedroom, a bedroom, and an open living area. Is that correct?
Yes, sir.
Then I see a pantry coming back the other way from the exterior wall. I see a pantry, a corridor, and a kitchen. And the kitchen appears to be separated by a wall from the office. So the access to that kitchen is right there close to the bottom of the drawing at what appears to be an exterior wall.
Yes, sir.
Okay, then we have a TV room that's open with a door on it. I don't know if that's locked or not. And then a bath. So the appearance of that would be is that the common areas include the one bath, because one bath is off of a bedroom, and the kitchen and a living room. Am I looking at that correctly and making the right interpretation?
Yes, it does. The main floor has what appears on here as a community bathroom. And then directly above that is the bedroom with the side bathroom.
Right.
Kind of has their own.
And so then on the A side, on the other side of the firewall, it looks like a community bathroom and only one bathroom on that level on the A side.
Yes.
Okay, so then when I look at the second side, or second page, which now I'm making the assumption is the upper level.
This is the lower level. This is
The daylight basement
the
level?
daylight basement. Yes, sir.
Okay. So then I see, again, unit A, we have a bedroom. And directly below that to the exterior or interior wall, I guess exterior wall, but it's a kitchen and dining and living combination area, joint open area,
Yes.
common area. And then so that must, then to the right of that, it says entry. That must be a direct exit to the exterior.
Yes.
And moving further to the right, looks like a bedroom.
Yes.
And that bedroom has access to its own bathroom. And is that the laundry and then?
That bedroom does not have access to its own bathroom.
No.
If you notice, you've got
There's,
a bathroom to the left and to the right,
Right.
both off of the hallway.
yep, and coming down the stairs,
Yes.
downstairs there.
Yes.
You turn right or left and to bathrooms. Okay, and then on unit B, we have a single bedroom with access to a bath. And then we have a living room, a kitchen and dining room with a stairway up. And then to the far right, a single bedroom and separate bath. Just so that
Correct, sir.
again, difficult to see that up there.
The only thing that's different on this one, just because Mr. Potts applied for a different permit right after this, at the bottom of that staircase, there's two doors. One that goes into that kitchen dining room area that's
Okay.
locked, and then to the left into that living area.
Okay. So in order to protect that stairway, you put doors on either side, so it kind of
Correct.
forms an enclosed stairway.
Correct, yes, sir.
And I assume rated doors at this point, or I won't make that assumption, but doors to slow transfer of smoke or prevent transfer of smoke.
All right, we're going to close the meeting here in just a second. Is there any other questions? Because when I close the meeting, it's just us, okay? Does anybody have any other questions? You good? Okay. There being no further evidence to be presented, I determine the record complete. The hearing is now closed and no additional evidence will be permitted. The board will now discuss the charges, facts, and evidence presented, then we will render our decision. And here's what I fall back on every time, folks, is this. And it happens where I work quite often. When we cannot come to a decision, just having a discussion about it, we always default to what does the protocol say? What does it say? It doesn't matter what it doesn't say. Are there locks on the doors? Who cares? That means nothing, zero. What we have to do is the city has to prove that this isn't considered a rooming house. I see where they have a common kitchen. I don't care. I've lived in places had roommates I really didn't know. We had locks on our doors. We shared the same kitchen. He had in the fridge, I had the top shelf, they had the next one. If they ate my food, we let them know it, right? So as far as locks and doors and all that, I don't see how that's relevant at all. What we need to do is fall back on what does the code say, all right? And the code says that these people don't have to know each other. It just has to be less than 6 people. Now, is in people's minds, is that considered a rooming house? For you, it may be, okay? But what we have to do is kind of wade through take all the emotion out of it and everything, and get back to what does the code say? What defines that? We can't say who's going to be living there or not living there. That's not our responsibility to do that. What we have to do is decide, did the city prove that, yes, this is a rooming house? And then did Mr. Davis present a case to the opposite of that, which I believe is a much stronger case, because all he did was mainly refer to the code. And so I don't think that the city proved their case, and I think it should be dismissed.
Well,
What do you guys think?
If I may,
Sure.
I also, this is one of those that has an appearance, but by the legal description of our ordinance, it says that you can have 6 or fewer, because no more than 6 is, I believe, but not more than 6 unrelated people living together as a single housekeeping unit. And when they're sharing a TV room, living space, or living room and kitchen space, that seems to me, I think, if there's any shortfall here because of the appearance, it's more so in the city ordinances and cleaning up to be more clearly defining what we mean here. And from what I've heard, it appears that Mr. Potts has complied with and tried to work with the city in every request. So I tend to agree with the chairman with regards to this matter.
Okay. All right. I move that the board dismiss this case without penalty. Is there a second?
I'd second.
It's been moved and seconded. All those in favor say aye. Aye.
Aye.
Did you say aye, Dwayne? Or Jim? Okay. Those opposed?
I oppose.
Are you abstaining? He's abstaining. Okay. The motion carries. Can we hear the next case, please?
Okay, so our next case is CEB 2021-0242. Ms. Johnson, will you please present your case? We're going to switch chairs for a second, so it's, board, please give us about 45 seconds. Starting now.
Okay, thank you. So chronic nuisance activity, a violation of the Pasco Municipal Code, was verified at the property known as at the Loyalty Inn, located at 1800 West Lewis Street. as of March 4th, 2021. A chronic nuisance determination notice was issued on March 5th, 2021, and delivered to the manager on duty, Jerry Hudnall, via process server. A copy of the notice was sent to the owner, Sohal LLC, care of Mohinder Sohal, via email on March 4th, 2021. Guests have complained of lack of maintenance, bedbug and cockroach infestation, suspicious activity, people loitering in the hallway, suspected drug trafficking and use throughout the property, and a lack of housekeeping services. A physical inspection of occupied rooms per guest complaint and request was conducted on March 2nd, 2021. The inspection of the common areas in just 5 units revealed numerous life, safety, and health violations. Violations included damaged door jambs, locking devices to rooms, broken windows not repaired after weeks or months of being broken, missing smoke detectors, gang graffiti, hazardous damaged floor and wall coverings, use of cooking appliances and space heaters in rooms, cockroaches, excess storage blocking emergency egress, electrical hazards, and unsanitary common areas. A reinspection of all guest rooms, especially those occupied on a long-term basis, common areas, and storage rooms, was required to be completed no later than March 9th of 2021. The results of the inspection showed that the majority of the rooms contained housing deficiencies. The deficiencies not only violated Pasco Municipal Code, but also Washington State Department of Health, Transit, and Accommodations associated WACs, which govern hotels and motels at the state level. On March 16th, 2021, the owner was notified via their attorney that since this is the second time under the same ownership and management that a chronic nuisance determination has been issued, a voluntary correction agreement would not be permissible. The city proposed action to be taken to reduce the nuisance activity at the property and to be able to consider abatement of the accruing daily penalty, which included correction of all life safety issues prior to the next inspection. A reinspection of the property scheduled for March 22nd, 2021 revealed that it was still in violation of the Pasco Municipal Code. Access to occupied rooms was not provided as staff had failed to provide required written notice to all guests. We were therefore unable to verify correction of housing deficiencies. The property has violated the criminal activity portion of the chronic nuisance code due to the number of incidents occurring on site. During the cited 180-day period of August 26, 2020 to February 1st of 2021, there were 11 warrant incidents and 15 arrests. I will provide more detail of those activities through the presentation. Based on the final inspection of the property, which was completed on March 31st, 2021, it is my opinion that the property is not in compliance with the Pasco Municipal Code. I'm going to go through a few of the photos and some of those nuisance activities that have occurred on site. So not only have we had criminal activity, but we've also obviously had housing deficiencies. This is not the first time that we're bringing a case against the Loyalty Inn, unfortunately. This is an aerial view of the neighborhood. That red outlined property right there is a separate parcel. It is 1800 West Lewis Street. It was the main office building and motel for that property at this time. There are 32 rentable rooms in that building. These other 3 buildings up here at the top are actually on 2 separate parcels. Those used to be a part of the motel. The far left end is an employees only building because of housing deficiencies. It is not allowed to be occupied by the public at this time. We have a fire damage section right here that is closed to the public as well. And this is a remodeled building, which is newer and better condition, but it's limited occupancy. It is on a separate parcel, and it is not included as a part of this case. You'll see that the majority of the neighborhood here is residential single-family homes. We have 1 retail space over on 20th Avenue on the far west side of the map. We have a couple down here as well, right adjacent to the motel building. We have a daycare just a block north, a new daycare that has just been approved over across the street. And there's a access on the east end of the main building, right where the cursor is. That is the most trafficked door in that property. So that's right across from where this daycare is going to be. We have a mini mart retail shop right here and a laundromat. So in order to be a chronic nuisance property, this is considered a multifamily residential property, which does include hotels and motels in this portion of the code. We had to have a search warrant or warrant of arrest or arrest arising out of occupants on the premises or arising out of incidents on the premises within any 180-day period according to the following schedule. So if we're looking at 32 rentable rooms in that building, we only needed 5 of those nuisance activities to occur, not even including code enforcement actions, emergency services responses to the property, or anything else. Per the City of Pasco licensing duties, the owner shall avoid all legal practices or conditions on the business premises which do or may harmfully affect the public health, safety, or welfare, including the taking of such corrective or preventative actions as are reasonably available, such as supervision, prohibiting lawbreakers and troublemakers from the business premises, reporting criminal activity to the police, and requested in writing by the city or manager or his designee. In addition, they are subject to Washington Department of Health Transient Accommodations codes under the RCW 70.62 and under the associated WACs in 246-360. So under that, they also, at the state level, advise that they must follow all other applicable municipal and county codes and ordinances. Due to that, we have requested in the past and have currently worked with the Washington State Department of Transient Accommodations to do inspections with us at the same time due to the issues that are there and the complaints we receive from the guests. So from August 25th, the day before that 180-day period, up through March 22nd alone, we had 12 contacts for code enforcement at that property. Each of these contacts was either an inspection at the property, an email that had to be sent, meeting with a police officer at the property to discuss issues on site, follow-up phone call to the manager to explain what these issues are that are going on. So calls for service to the Pasco Police. During the cited 180-day period, we had 247 total calls for service in a 32-unit building. And that's just the number of times the police were called to assist. Now, in the code, we do remove anything that was called in by the manager or an employee of the building. So those calls, if they had an incident included in them, are not in the total number of the 26 arrests and warrants executed on the property. So these are things that are called in by guests of the property or surrounding neighbors and residents. During the period of February 2nd to March 4th, that's between the dates of the 180-day period and the service of the notice, we had 106 total calls in that 1 month period and 3 arrests. The service of the notice occurred on March 4th and officially on March 5th. So during the time frame from March 5th through to today, we had 42 total calls of service and 4 arrests and warrants executed. So unfortunately, the criminal activity did not cease during that time frame while we were working with the property owner from the date they were notified. These are the incidents that included response by Pasco Police that we've cited as those 26 items. I'm not going to go through every single one. I do have the dates on here. I do have the items as to what happened, but each line item signifies an arrest. A lot of these include stolen vehicles, narcotics. We have drug paraphernalia. We have assault at the property. There are many people being found on site that either have violations of court orders or they have felony and DOC warrants, and they're being found there and arrested on site. This is the second page of those same issues. These next slides are going through the inspections that we've conducted at the property over the last month. On March 2nd, this is the day that we went to inspect based on guest complaints. We looked at about 5 units. There were several others that were not wanting us to go into their rooms those days, but they did say they had cockroaches and bed bugs and had complaints. So as you can see, the floors are dirty. We were notified by manager on call that day that all of the housekeeping was on call. They did not have a regular schedule to come and clean these hallways. We were notified by guests that there is not regular housekeeping inside. Many of these people have been here for more than 30 days, and some of them more than a year. So we were once again using a transient accommodation as a rental property without proper licensing or inspections, not meeting code. This is the end of a hallway where we had a window boarded up, AC unit boarded, without proper repair of the surfaces, graffiti throughout the hallways as well. Majority of the door jambs are broken. They are not properly securable. We don't have the minimum lock throw for deadbolts or for any kind of lock in those door jambs. We're using cooktops inside of the units, which are highly hazardous. cockroaches throughout. As you can see, this is a cockroach that somebody had kept because it was crawling on them in the middle of the night and wanted to show us when we came for our inspection. And on the right, that is cockroach feces throughout that paneling where you can see that they've been hiding behind there. This is the east side exit door I showed you on the map where it's right across from the daycare. People use this door to bypass the lobby. So at the lobby, they do have a sign-in sheet where they require guests to write their name and the room number. Most of those names are not legible, so you don't know who's actually coming in. And when they don't want to go through the lobby, they just open this door. Inside the rooms, again, we have broken door jambs, electrical outlets that are not properly secured. It's kind of hard to tell in that picture on the right, but the floor is actually sunken in right in front of that exit door, which is an emergency exit. These are windows on the front side of the property. There are 3 windows there in circles that are broken. 2 on the left, those are emergency windows. And those are the sliding portions. So the movable portion was boarded over with wood and not repaired. These had been in that condition for at least 2 weeks prior to our inspection. Exterior of the property, we have litter, we have broken concrete blocks. This is the lobby. Walk in, torn carpet. In the lobby area next to the coffee area, we're storing miscellaneous debris, mattresses, which are highly flammable. Graffiti in the rooms, poor maintenance of everything inside. We have damaged trim, missing outlet covers. On the right, that's a water leak from the window. Again, another broken window on that bottom left corner. You can see where it's cracked, and that tenant said it had been like that since they moved in. We also have a broken door lock. So these are electronic door locks on the motel using a key card. This is one where a tenant actually installed a fireplace inside of their air conditioner housing. And then broken benches inside. So I would assume that if they were doing their daily housekeeping or even weekly housekeeping, these things would have been caught and would not be as much of a hazard. Where we're using this as a de facto rental property and it's not being inspected or monitored, then these kind of things are continuously happening. Again, broken glass outside, broken window locks on the first floor where people can easily enter the rooms, missing smoke detectors. That's also a water leak on the left side. Overcrowding in the rooms. This is actually the hotel laundry room where we have blocked egress through the aisle. This is a hardwired smoke detector, which is improperly wired to a plug-in and then plugged into an outlet, and then exposed conduit boxes in the ceiling. Again, just damage and overcrowding in the rooms. Personal cooking appliances being used inside the hotel rooms, such as these, are not permitted. This is again back to the lobby at that main entrance where we have torn carpet. We're back onto the re-inspections as of March 22nd. Again, we were not able to access any of those occupied rooms to verify any corrections had been made. There were several rooms where the people had been occupying them for over a year where we've never had any access to them. You can see that the mattresses that had been stored inside the motel rooms and in the lobby area were instead moved out by the corral in the parking lot. And if they were waiting possibly for pickup by garbage service, but we still have a lot of debris left in the lobby. That door had not been fixed. As you can see in the middle picture, there's actually a screw inside of the door strike plate, which prevents it from being locked. Again, that's a fire door. That does need to be able to be properly operated. And it's also a security concern where people are still bypassing the lobby. Manager also notified us that there is no camera on this side of the property. There is a camera on the exterior, but nothing inside. So we do have a lot of the criminal activity that is taking place in that portion of the building, but it's not being observed. Spliced electrical wiring, broken door jambs, broken window locks. Again, it's the same stuff as we had before. This is improper electrical wire splicing being used. The windows were completed as far as the glass being replaced. So that's my final inspection as of yesterday when I drove by. I have not been into the property again since March 22nd. We still had some trash and debris outside, a vehicle with flat tires. But we did receive pest control receipts from January 15th, February 10th, and March 5th showing that the common areas had been treated, but not the individual units. And we received yesterday an over-the-counter building permit to replace that commercial door. However, the work still has not been done. And mind you, our chronic nuisance case started on March 5th. So, again, the city believes that the property is not in compliance. City of Pasco recommends that Sohal Development LLC / Gertie Corporation, which is the state licensing name, care of Mohinder Sohal, shall pay $45 to reimburse the city for cost of personal service of the notice, and pay an immediate monetary penalty of $25,000, which accrued at a rate of $1,000 per day from March 5th, 2021 through March 29th, 2021 for failure to abate chronic nuisance activity on the premises.
Okay, I just have a quick question for you, Ms. Johnson.
Yes,
So
sir.
we are only talking about the 32 units hotel?
Correct.
Correct, none of those other buildings?
Correct.
All of this was from the hotel?
This is all from that red outlined building
Okay.
that has 32
All right.
rooms.
Okay.
Yes.
All right, who'd like to be heard in this case? Come on up, gentlemen. If you'd state your name and addresses for the record, that'd be great.
Good evening, Board. My name is Ben Bulmer. I'm an attorney over at Powell and Gunter Law Firm in Richland. And our address is 1025 Jadwin Avenue, Richland, Washington, 99352. I'm here with the owner of the property, Mr. Mohinder Sohal. And Mohinder, can you state your full name and address?
Yeah, Mohinder S. Sohal, 24433 Southeast 192 2nd Street, Maple Valley.
Okay, go ahead. What would you like to tell us?
Thank you. First of all, is it normally go this late? Is this kind of par for the course for you guys?
When attorneys are here.
I commend you. That last
I'm
case
just telling you the truth.
I was at a closing I had today, and I got to work at 5 o'clock this morning, and it has
Me
been
too.
a long, long day. So I apologize if I'm a little scatterbrained, but it truly has been a long day. That was an interesting case. I know Brian Davis. He's a good attorney, and I thought he did a good job. I'm here obviously on behalf of Loyalty Inn. And there's a lot of stuff that was covered there by Rosanna, and I've dealt with Rosanna in the past quite a bit, and she's been great to deal with. But I just wanted to go over a couple of things, okay? The first thing is that the owner is diligently trying to fix these items. He received, so it says in here that they were served on the 5th of March. That was served on Jerry Hudnall, the property manager who's on site. My client lives on the other side of the state. They emailed him. He doesn't check his email. He doesn't speak great English. And he didn't really catch wind of this until about March 8th or so. They were supposed to have the things fixed by March 9th, which, as you can see, there was quite a bit there that the city was requesting. Quite frankly, just an impossible deadline, right, to fix those things. We asked for more time. They gave us to March 22nd, which is again only like 13 days. So I'm just going to go over kind of the status of where things are right now. Okay. So the first thing to know is that my client is under contract to sell this property. Okay. So he entered into a purchase and sale agreement on March 5th to sell the entire property. So this is all sort of going, I mean, any issues that the board sees are really going to be gone, right? I mean, this is not a long-term problem. So he's under contract to sell the property to a third party, unrelated, not a family member. This is truly a legitimate sale. There's a 60-day feasibility contingency in the purchase and sale agreement, which means that the buyer has a period of time to inspect the property, make sure it's going to be suitable for his intended purposes. He plans to renovate the entire property, is what he's told us, and to also rezone it if he can. So that's what they're doing. Again, I'm not really, I don't represent the buyer, right? But that's their plan. And so, we notified Rosanna and Troy of that, that we were, and just to give us time, right? So that's just an important point I wanted the board to understand, is that that's happening, okay? And one of the things in the agreement is a requirement that the property be vacant at the time of sale, okay? And so that's a challenge right now, right? So right now there's a moratorium on evictions, right? So the governor has issued a moratorium, there's 3 exceptions to that moratorium, right? So the general rule is you can't even give a notice to anybody to ask them to leave a property, right? But there's 3 exceptions. One of the exceptions is if you're planning to sell the property, you can give a notice. But the notice is a 60-day notice, okay? And so we've issued those 60-day notices. Those were issued this month. The soonest they can, they expire the end of May, right? So it has to end at the end of a month. So May 31st is the day which the 60-day notices expire. It's unfortunate, but for a lot of these people that live at the Loyalty Inn, this is the last step to, or the last their last chance before they go homeless, right? So quite frankly, this is not necessarily a great result, but that's where it is. So the property is going to be sold. The notices have been given to the tenants or the occupants. At this point, I think there were 21 notices that were served, and I think, I could be wrong, but I think 3 or 4 of them have already moved, okay? And so we expect that more will likely move in the near future. And another thing to note is that the owner has made significant repairs to the building, and I know, that code enforcement wanted those repairs done like within days, right? Just very, very quickly. But I'll go over what he has done. So any windows that were broken have been fixed. So it takes time, right? You got to hire Tri-City Glass. They're not necessarily going to come out same day and fix that kind of stuff. They set an appointment. So all the windows have been fixed. He's replacing the back door. Okay, so that back door that you saw pictures of. Right now, people are able to come and go, ingress and egress. And what the problem is that the front desk is not able to monitor who's coming and going from the property. So there's really 2 entrances and exits to this property. The front door where the lobby is, where there's somebody working who can monitor, and there's a check-in sheet. And then there's this back door that apparently people have been sort of sneaking in and out. So what they're doing is they're putting in an emergency access or exit door. There'll be no handle on the exterior of the door, right? So nobody can come into the property using that door. And if somebody tries to exit the property, it's going to be alarmed, right? So it's an emergency exit only. And that's something that the city suggested. They had Home Depot come and look at it first, and that took some time, and then Home Depot told us they couldn't do it. And so then they hired another company. Oh, Mahinder, what's the name of the company? Do you remember?
For which one?
For the install of the door.
It's M&M, I think. I already sent, gave them a letter.
Yeah, so there's a contractor who's coming out to do that. That's occurring, they say, middle of next week, okay? And so that's happening, and they've obtained their permit. They have working smoke alarms and carbon monoxide detectors fixed. They've been recarpeting and putting new flooring down. I know they recarpeted at least one of the rooms and put flooring down in several places throughout the property. They've installed new light covers throughout. They're currently working to replace all the base trim in the building and the trim around the doors. They have a maintenance person now who's working full-time on these issues to get them fixed. They're fixing doors, fixing door locks, door handles. They've installed toilets. They've been just numerous different things. They've hired a security company at the just recently. So this month they hired Phoenix Security. They come and monitor the property on a daily, nightly basis and go in and make sure that there's nobody loitering in the halls and making sure that the doors are locked. They've hired a maid to clean the property. And so that person is in charge of sort of keeping the property kept, cleaning the common areas and also cleaning the rooms as they are permitted to be, right? And I'll get into that in just a minute, but a lot of times the tenants will not let people in. There's also now an around-the-clock front desk person. So there's somebody working at all times at the front desk monitoring. So just to reiterate, there's only going to be one entrance and exit to this property moving forward, and that is going to be monitored 24 hours a day by the staff and also by a separate third-party security company. Okay. Another thing I wanted to mention are the occupants. There's some of the occupants that just, quite frankly, will not allow people in, right? So they have a pest control company or contract that allows the pest control people to come in. Many of the occupants will not allow the pest control people into their rooms. They have problems where they treat one room but they aren't allowed to go into other rooms, and so it's difficult. It's a very difficult issue, and so but they have had pest control there. They have a contract, and they come regularly to treat the property. Just in general, trying to get access to the rooms to make repairs has been a challenge, right? So, Mr. Sohal he came from from Seattle area here to work on these repairs and has had a lot of challenge trying to get access, just to do basic repairs and
How many, Mr. Homer, excuse me, sir?
Yep.
How many rooms are we talking about that the occupants won't let him into to look at or do the pest control? How many rooms are we talking about of the 32?
Out of 32, there's about maybe 8 or 10 empty now. And
Okay.
maybe 20, there was like 24, 23. They all extended stay, and they won't let you in. And they cooking, some of them cooking, some of them not. And if window is broken, then we have to order windows, which take like four weeks. It's very, very, all the contractors, they're so busy. You can't get it right away. And we order the back door, the panic door, we already ordered that. Science City told us, you should put a panic door, an exit door. They only can use the front door. But these people don't let you in because and the governor, Jinsley, he said you can't even evict them till end of June.
Have you been, well, I guess no, we've been in COVID, so you probably wouldn't have been able to.
And the COVID-19 is a really bad thing. And a lot of
Have you, okay,
homeless people come in.
I
They
understand.
get to shower in these rooms, and
Yeah.
sometimes they bring box,
Mr. Homer,
Yeah.
have you been to the property
I have been to the property before, yeah.
and you walked recently?
I have not been recently. I'm trying to think the last time I was there was probably over a year ago.
Okay. So what we have is the city has tried to work with Mr. Sohal a lot. And not just with the hotel or the motel, but the other properties, those other buildings as well. And gosh, Mary, how many? I can't tell you. It's been a few. But I guess my concern and question is that okay, my question is, if the city went tomorrow, if Ms. Johnson went tomorrow, all those things that you talked about are going to be fixed, right?
how not work, no.
Oh, so which ones wouldn't be fixed?
Like emergency things, like smoke detector, windows.
So that's a good question. So to reiterate, the windows are fixed.
Mhm.
The doors being installed next week, so that's not gonna be, if you came tomorrow, that's not gonna be fixed, right? The smoke alarms and the carbon monoxide detectors, those were kind of like the first priority. But again, I mean, you go in there and you fix them, and I can't tell you that, I
Right.
mean, what's happened in 24 hours, right? He went and fixed a window, and within just a short period, it was broken again, right? So, but I said they've recarpeted some of the rooms. They've put flooring in some of the areas. They've installed new light covers. Okay, they're currently working to replace the base trim. I talked to the maintenance guy today. He said that they're there. He's like, that's what I'm doing now. I'm putting in new base trim everywhere and putting new trim around the doors. Is it done? No, but is it happening? Yes. Right. But again,
How many rooms has the trim been done on?
I didn't ask him.
Like all the hallways been trimmed. All the normal area where people walk in. But other tenants, most of them, they don't let us in. And no contract, nobody wanna go in there. And they're not getting out, there's 2, 3 people in there, in the room, and they don't wanna go for, like, if there's 3 people in the room, I'm a maintenance man, I won't go into that room, and unless they go out, or they don't go out. And that's a problem with COVID-19, that's the main problem.
So, and just to reiterate that, you know, it's, and even, there's issues with COVID, right? So tenants don't want you to come into their room, at least they say it's COVID, I don't know. And there's also the issue where people, you know, employees, maintenance people don't want to go into these. I mean, it doesn't sound very exciting as a maintenance person to go into 21 different rooms when there's 21 different families or people living in these, or staying in these rooms. And so, you know, it's a challenge, but the idea is that they're supposed to go out when the maintenance
Right.
people or the maid or whoever comes in and does whatever job they're doing. But, you know, there's things that need to be fixed that are being fixed. And like I said, he's got a maintenance guy now, he's got a maid person, they've got security, they've got the door, you know, but, you know, to expect all that to be done in like 13 days is just really a challenge, you know, to do.
Now, question, is Loyalty Inn a motel, hotel?
Yes,
So it's not an apartment building?
is not an apartment building.
Isn't there a state limit on the amount of days you can stay in a motel
believe
or
it's
hotel
30.
room?
And so what they typically do is if somebody's getting up to that point, they make them leave. Hunter, you can check me if I'm wrong, but they make them leave and then reinstate, you know, if they're gonna come back, or they make them.
Now, when you told them to leave, or they didn't leave, they say it's coronavirus.
Well, then you need to go through the courts to have them removed.
That was a problem.
You can't evict anybody.
I don't know if COVID, I don't know if COVID applies to motels.
But what happened is some people, like, they stayed more than 30 days.
Well, then you have to evict them,
Yes, we already gave them notices now,
okay? And
at the first,
But the only,
first of this month.
but just to be clear, the only way you can evict somebody right now is if you're moving into the property, you're selling the property, or the tenant is engaging in behavior that's a
yeah, but
significant and
I think
imminent
what the
risk.
definition of tenant is someone that is renting an apartment
Right,
or a home, not a motel room.
okay. Yeah, so, well, I thought you
So-
asked what you're doing with the tenants, okay. So you're asking,
Well, you're saying tenants.
Yep.
Okay.
so what I'm
You
saying
can't
is,
evict a tenant.
I would say guest.
yeah, well,
Okay.
whatever you wanna call them, but occupant, okay?
Yeah, but I
whoever-
don't think the state law, the COVID-19 exemption applies to motels or hotels.
But if you try to get the police to go and evict some, you know, they're not gonna do it. The people
Yeah,
that say,
okay.
we've been here, and good luck, right? I mean, you're not gonna get them to,
The other, so if I was to believe that it's only been since COVID-19 that hotel looked like a normal, clean hotel a year ago? When you were there a year ago, what did it look like?
I don't know that I went to the lobby
Yeah,
in that building, and then I went into one of the areas in a different building in the northeast part of the property. I don't know that I've toured this building, so I don't know.
yeah, you know, I appreciate that you can't do anything about with the COVID-19 stuff, I understand that, but I think this has been going on for a long time.
Yeah, many years.
And we're pretty familiar because we've been here a long time too. And so what we're trying to decide is, and what we hear every time, whether it's the hotel or those other properties, that all these things are being done, and then the next thing you know, we're right back where we were again.
Has Loyalty Inn been in front of Code Enforcement Board before?
Yes.
Yeah.
I got one.
Okay.
Before I got a problem with, I usually have 43, 44 studios.
Mm-hmm.
First, I used to get a problem with it. But over a year, I don't have any money to spend it, so I just closed that down.
Mm-hmm.
And now, I'm just renting the lobby building of 32 rooms.
Mm-hmm.
I got a renovation building, 43 rooms. I don't rent that one
Mm-hmm.
because there's no occupancy. I got about about 76 rooms plus 43 rooms. They're all empty, only occupied is the lobby. But what happened, people stayed. You can get them out if they stay like less than 28 days. But what happened, most of them stayed over 30 days. Even if it's apartment, even if it's a motel. After they stayed more than 30 days, they come from guest to tenant. Then those are the ones you can't evict them by the government. The only way you can get them out, either if you want to move into the property, or like I'm not going to move into the motel. I only need one room if I want to move it. I can evict one person. But if it's house, then you can say, yes, I want to move into it. But this is a motel. Anybody stayed more than 30 days, you can't evict them until end of June. It was a March 1st, then the state and the federal, they extended till end of June. The only way we can evict them if you are selling the property. And we are selling the property. So, like if the toilet is broke, only empty room toilet is broke. Not the guys who are living in any room. Nobody wants to stay if the toilet is broke. Like many rooms, like what we call is the red tags, we put a red tag, like in the computer and on the board. Like one room is this room no good, this room no good, this lock no good, no good. We don't rent them. We just put a red tag. And if city enforcement come, they will take the photos of all the red tag room. And also one of people living in, when they start cooking, we can't stop them. They take the smoke detector off. That's what, and we keep telling them, don't do that, but nothing we can do.
So, and right now, in the, during COVID, obviously the property is struggling, right? I mean, it's probably at, the hotel is 20 or less than 20% occupied. Mr. Sohal is losing between $7,000 and $8,000 a month at this property. Okay, so he's losing money, hand over fist. He's having to pay all this. The door alone is another $3,000. And again, this is all temporary stuff, right? So he's selling the property. This is he's spending all this money just to get the property, ready for the next 2 or 3 months until he gets everybody out and sells the property. All we're asking is to waive the $25,000, which is just going to add to, just add insult to injury to him, right? He's just, like I said, losing money, and give him time. Give him time. It's going to take at least until the end of May to get these people out. And sell the property and move on, and then there's, like I said, I can't speak for the owners, but that's their plan is to renovate the property. So again, this is a financial hardship for him already. He's suffering through, and just his other businesses, losing money. And so to add, another $25,000 in the middle of COVID is just, it's rough, and it really has not been very much time, to get these repairs done. So I think he's trying. He's trying to do what's right. He's trying to sell the property. He's trying to make the repairs that he can. So that's what we're asking. We're asking to allow us to enter into an agreement. We're happy to do that in writing, and allow us 90 days. I think the municipal code allows up to 90 days. And I think that's, normally I would say to do much faster. If we were not in COVID, we could obviously do this whole process much faster. But, it is what it is. That's the world we're in. So I don't see how we could do it any faster than that.
Mr. Vollmer?
Yeah.
When was the tenants, when did they receive the eviction the paperwork?
I would have to check and see, but the bottom line is it doesn't really matter because if it's issued in March, any day in March, the sooner it has to be, you count out 60 days and then you go to the end of that month. Does that make sense? So
It does. So were they all served?
they've all been served. Yep. As far as I know, I think we did 20,
Yeah, they
21.
also-
Yeah, every occupied room that's giving us issues, right? That's not a typical hotel motel.
So out of the 22 or 23 rooms that are left, all have been served, and that was
In March?
It was
There
in
was-
March.
There was 21, I think there was about 21, 23.
Something like that. I think it's 21.
Okay.
They all been served.
And
And
I
that
think-
was
I'm saying they also,
just a few days ago they were served, or a week?
no, I think that was served. When
I
we
honestly
saw-
don't remember. I'd have to check and see, but
think it was
like I
last
said,
Friday.
it doesn't make a difference when they were served as far as when the dates. I mean, it's May 21st or May 31st if you served in March 1st, or if you served in March 30th. You couldn't do the 31st because it has to be 61 days, actually.
Well, I think it matters a little bit, because if we started this process on the chronic nuisance, the daily penalties on the 5th, and it took 3 weeks, 25 days for any action to happen, I think that would show if Mohinder actually jumped on it and corrected all the issues within the first few days, or a good portion of it, the city would have understood that, and the city would have worked with him like we have a dozen times before. But as we stressed multiple times to your manager and to you, if you wait 25 days before you start doing anything, that's kind of out of the city's hands. So that's why I'm curious, when was it served?
I can speak to that. And Mohinder, I mean, we talked about that. The plan was to get them served all along, right? But I told Mohinder that it doesn't really matter when you serve these notices in March, whether you serve them, the day we first talked about it or March 30th, it's all the same, right? It's the same result. And so-
Understood.
Yeah,
I understand that.
so his plan from day one was, we're selling the property, he entered that agreement March 5th, I think.
Mhm.
And he knew that he had to, and so I just told him, they gotta be served this month. And so, Jerry was collecting the names
Right.
of the tenants, putting together, it's 21 notices, right? And so I just told him, hey, look, we need to get this done. The latest I would do it would be, you can't do it the 31st, because it's gotta be 61 days if they're posted and mailed, on the door. So we had our process server, we let them know, it's gotta be done prior
Right.
to that. So-
I'm just very concerned with our required egress windows. It's taken 3-4 weeks to correct. Our required egress door, still not corrected, and it's almost a month. Smoke detectors, CO detectors, slowly getting corrected. Sounds like they kind of keep getting damaged. There's other ways you can do it. You can screen them. They make screens for them, kind of like in gymnasiums that you can go over the smoke detectors. There's other ones that have an actual alarm on them, kind of like the alarm that you're going to put on the door that we suggested. So those are the items that you could be doing. So that's why I'm trying to get to the point where, what have you done? And why are we waiting a month to do it?
First, we didn't give notices because the governor say this evictions was till 31st March, right? Then I think 30th or 29th month, then he extended. First it was till
That is true.
31st month, right?
So the moratorium was scheduled to, that's true, we did talk about that. The moratorium was previously scheduled to end at the end of March, okay? And then for the 5th time, I think the governor extended it. And so one thought that we had is if the governor does not extend the moratorium, which there was actually talk of him maybe not doing that, or maybe, not extending it, then we wouldn't be stuck with the 60-day notice. Because if we give a 60-day notice in March 15th, say, and then the governor goes and decides to not extend the moratorium, we're still stuck with a 60-day notice out. Does that make sense? So if
Absolutely, it
Yeah.
does. And even if this lasted 9 more months, I get it. That's out of our hands.
Yeah.
But the life safety issues are not. Those are in our hands.
I just-
That's what
yeah.
we have to jump on, and we have to make sure that everybody that there is safe. So again, why is it taking 25 plus days for all of these life safety items to be taken care of?
But all these smoke detectors was fixed right away.
Okay, so if we walk this facility tomorrow, all of the smoke detectors and CO detectors would be fixed? So if you're saying if we walked it tomorrow morning, all of the smoke detectors, CO detectors, egress windows, egress doors are fixed?
I don't know about the doors, because doors you need a contractor or carpenter. About the smoke detector, anything that with help, right? Which people will let me go in the room. I'm 100% sure that smoke detector will work. If you even come, you tell me if you want to come 1 o'clock. You know, if they don't let me in, there's nothing I can do. Because some people, when you give them eviction notices, like one like 297 complaint, right? She's not paying rent. Then what she gonna do? She gonna phone the city. Oh, I got a problem here. And she gonna take us, lamp, ceiling lamp off, do this, do that. They're gonna call you, and you guys gonna come and take the pictures.
Right,
There's many people like that.
and I understand that, sir.
And last time you came, when you walked with me,
Uh-huh,
didn't you see any, all the carpets was shampooed?
yes, yes, I did. They were shampooed.
All was shampooed?
Mhm.
And which rooms was empty, I shampooed,
Mhm.
and the guy left, then he said, I have to come back 5 o'clock
Mhm.
for the rest of the rooms.
Mhm.
So I try to clean like much as I can. But if anybody comes from the back door, even I, clean it, because they keep breaking in, and they can grow a little.
And they do it on purpose.
Agreed,
Yeah,
and I get that.
21 evictions, there's going to be a lot of problems.
There's gonna be
If they're gonna
significant,
trash the room,
yeah.
the people are going to trash the room, that room can't be fixed in a day or 2, 3 days, if they trash the room.
Right, so the last thing the city or I want to do is do an emergency condemnation, right? That is the last thing I can do. But honestly, we are really close into that. So what would happen was, we would have to go in there, we would evict everybody, and we would put them up in a different motel, and then charge you, right? That's the last thing we want to do. Because how it can be done is because it's unsanitary and unsafe, right? Emergency egress windows, emergency egress doors, smoke detectors, CO detectors, fire extinguishers, everything that is life safety has to be done immediately. I haven't seen that. I have not seen that.
Wait, I think all those things you just said have been done except the door.
Okay?
Which
So
is-
there's other alternatives that we can do instead of waiting a month to fix the door. And I have not gotten one suggestion, but there's a lot of things we could do. We could have a man stationed there.
But if the door is not, like door jam, like those empty rooms, right? Why you guys consider about the empty rooms if I'm not renting? For example, I got 5 rooms, right? They're all empty.
Right?
I make sure they got a smoke detector,
Mhm.
even they got a dirty carpet, right?
Smoke detectors, broken windows, cockroaches, bed bugs, yes.
On that, unless I put a red tag room,
Mhm.
when you come up, like you go in, when you go into my rooms, most of them like a red tag, right? If the lock is broke, I can't fix the lock right away. We have to get the parts, we got to order it, sometimes it takes 3 weeks, to come from out of state.
But you can secure the door. You can secure the door.
Yeah, we can screw
Even
the
if
door,
that doorknob,
we can
even if
screw
that doorknob is broken, you can still secure that door, right?
Yeah, we can screw that door
Right.
completely.
There was many
so
doors that
nobody
were,
can go in there, even if I put a lock on there like a board,
right?
then you won't like that either.
Mhm. But even when we were there a couple days ago, there was doors that had broken locks, just broken assemblies completely that could not be shut, could not be locked,
And that's
could not be
what
secured.
What I do if the door is
Okay.
broke, I'll put a plywood.
Okay. 247 police calls in 247 police calls in 6 months, 26 arrests, 106 of those calls in the last 30 days. I'm sorry, between February 2nd and March 4th. That's just in 1 month. I mean, this is a problem property. And I get you're committed now. I get that it was a snowball effect. You let them go past that 30-day. Now they're no longer transient. Now they are tenant. I get that. But you still have to strive for all of life safety issues. Because if something happens, that's a huge deal, right? We have a lot of issues at that property. I think we all can agree that. And now we're almost a month into this. right? We're 4 days away from being a month from our first initial inspection. This time around.
But the main problem is, you told me, hey, put the back door where people coming in, right?
Yep.
You suggest me,
Yep.
you can put that exit door.
I did.
I thought, I can't put exit door over there. Because some people check in their back door. So now you suggest me that I order that door. That door is gonna cost me $3,000.
Right.
He said, man, I'm a contractor. And I explained to you, he said, this door is not a proper commercial door. I have to order the frame and, then we have to give to the machine shop. It's gonna take like 4 weeks. And we keep calling him and finally we call him today. I told Jerry 3 times, call the contractor. Right? And
Okay.
he said, I think they're coming next
I mean, I
week."
think on that issue, the question is, when did he start trying to get a new door? Because I know even before that, he called Home Depot, and Home Depot came out and looked at it
Yeah.
and said they don't do those kinds of doors.
Right.
And that was weeks ago, I know that. So I don't think, what you're saying is it's 20 whatever many days, like we're
Right.
just now doing it, right? I mean, we didn't start 24 days later to fix these issues. But I don't know if this is
Yeah,
productive or
because
not,
that's
but
Home Depot,
yeah.
Home Depot
I-
said,
I understand
we'll
that.
do Next week or 5 days for the measurement, that guy came for the measurement, then after he gone, then after 2-3 days, he said, we don't install
Okay.
commercial doors.
All right, I'm just gonna interrupt for a second here. I want to ask the city a question. Was Mr. Sohal notified, because maybe I wasn't here the month, that between March 5th and March 29th, that there was a potential that he could be fined $1,000 a day, up to 25,000?
The chronic notice itself states that you'll be fined $1,000 a day as of the date the notice is served in it. And that was served on the 5th on the property, and I also emailed it on the 4th to Mr. Sohal to make sure that it made it to him.
Did you get that paper, sir?
I think I got those papers maybe online.
Because if
I got those papers online.
For me, I'm just talking about myself, but if it was me and I knew that I could be fined $25,000 if I didn't make progress and almost do all those things, I'd be all over it. But what my understanding here is that the city has worked with you like crazy trying to get you, and you've delayed it to the very end, which that tells me that you're not really interested in doing that. You're just trying to get out from under it, stretch it out long enough to where you'll be out from under the property. And then there's the safety issue that they talked about. Those things have to been done. What if there was a fire?
Yes, safety.
Come on up, get up closer to the mic so folks can hear you. Go ahead.
Yeah, safety issue was like smoke detector, that's a safety issue. That was done right away. And I told, even I was not on the property, I told my manager, I do that right away. Because smoke detectors only take like 1 or 2 minutes to
Right.
put it back. And some tenants take it off and put it on the floor and they don't let you in. That's a big problem.
Yeah. Well, and I appreciate that you have this property that over the course of time has gotten to where it's at. I understand that. But it's still, you as a property owner, it's your responsibility to make sure these things are taken care of. And if it ends up costing you more than you're taking in, then that's what happens because you're the property owner. It's on you.
Well,
Go ahead.
I'm just going to add that I represent lots of hotel owners right now and property management, probably most of the big property management companies in the Tri-Cities. And 20% occupancy, 30% occupancy is the norm. Doesn't matter what the condition of the property is. And also apartment complexes. I mean, we got a lot of apartment complexes that are 20%, 30% of the tenants that are residing there are not paying rent.
Yeah.
And he's got, of those occupied rooms, 6 or 7 of them are not.
They're not paying rent.
They don't pay rent,
They don't
and we're not trying to evict them because they're not paying rent, right? I mean, that's not the point. But it is financially, this is unprecedented times for that particular industry. Restaurants, hotels, apartments, right? I mean, it's landlords. just
Okay.
getting killed. So I'll just say, I mean, I just don't want you guys to think that he's just got tons of money and time and is just not dealing with this, right? I mean, this is, he called me immediately, said, I've hired an extra maintenance guy, I'm trying to do this, we're trying to fix it. And truly, I mean, that's the truth. He, we got the, like we said 3 times now, the carbon monoxide, the smoke detectors, all the immediate issues were resolved. I think he's doing the best that he can under the circumstances. I mean, without, he's working on the trim, he's working on, he can't get occupancy at a lot of these rooms, right? So there's just not.
The thing that bothers me is that why are we waiting until the city has to go in and do an inspection and find all this stuff?
Yeah.
Okay, that's where I'm at on the whole thing. And it's like, why does that have to be the case? How long had it been? How long have the smoke detectors not been working?
And again, he's not able to go in and access.
Oh, I know, but there's employees there.
I know.
The employees can't go in there. I mean,
No, I'm not talking about individual rooms, but there's other ones that there's things that were broken and could have been repaired. Go ahead, sir.
Yeah, but in the hallways,
Mm-hmm.
in all common areas, they're all secured by more security.
Mm-hmm.
Nobody can touch them. But in the rooms in that building, just those 32 rooms, they just individual, but they're wired, right, and non-wired, right? But when the people living in, when they're doing cooking without authority, then they took it out. But there is not any smoke detector missing in the hallway, this and that.
I understand.
and just one last point. I mean, I just don't want you guys to feel like he's literally selling the property, evicting everybody. I mean, you can't be any more drastic. He can't. That's about as drastic as you can get, right? I mean, I can't overstate that, right? I mean, it would be one thing if he had not done anything, or if he'd only done, the smoke detector, but to literally serve a notice on 21 different occupants who very well likely could be homeless because of this. The occupancy rates in the Tri-Cities are very high, and it's difficult to find a place. It's drastic, right? I mean, this is his livelihood, and he's literally selling it. And he, like I said before, he's got a maintenance guy, and he himself came down from Seattle at how old? 60, 70?
What?
How old are you?
I'm 67.
67, and was in there trying to fix these things for days. And walkthroughs.
Is the property for sure sold? Is it a done deal?
It's under contract. No, it's not a done deal. So it's I mean, in a commercial real estate transaction, the normal course is you enter into a purchase and sale agreement. There's typically contingencies in there for financing and for feasibility. And usually those run anywhere from 60 to 90 days. In this particular case, it's a 60-day feasibility contingency. If the buyer is satisfied and able to get his financing and all that sort of thing, which I think this buyer is serious because it's a good deal, but then they will close. But the closing is not scheduled. That's what I'm saying. Is it would be, if it was a done deal, we wouldn't be here, right? I mean,
Right.
we wouldn't be the owner. So,
Yeah.
but that's the plan, right? And so that's a big deal. It's so I just feel like to add another $25,000 onto his already big financial problems at this point is very punitive and would be would be really harsh.
Okay.
I really so, and I understand your concerns. I truly do. I mean, I get it, but given the circumstances that we're in right now with COVID, this just to go serve all the notices, right? You're paying a process server $65 a pop, right? You're paying, your attorney to show up here. You're paying, it's just like he's just dealing out money hand over fist, and he's losing money at the property because of COVID. Normally these occupants would not be there. He doesn't normally have this kind of, that many occupants not paying rent. And he's trying to, I don't know, it's a bad situation. I get it. And I think this is a solution that works for the city of Pasco. It's a solution that works for the property owner. And we just need to get through, it. So I don't know what, if there's some particular, Mr. Hendren has mentioned some things, that if they want us to board up the doors to the closed, or to the rooms that are not occupied, if they want us to man a person at the back door permanently until the new door's installed and, the contractor can get there and get it done, we'll do it, right? I mean, I don't think that's an issue, but to say that he's not doing anything, I think is not true.
No, we understand there's some things getting done.
Yeah.
Mr. Chairman?
Yeah, go ahead.
I have a question of, probably for the city more so than, with regards to the smoke detectors, I know it's a technical question. Are they single station smoke alarms or are they part of a fire alarm system in the building?
Only the ones that are due to the age of the building, the only ones that are monitored are the ones in the corridors.
Okay, so.
And that was, I'm sorry, I didn't mean to interrupt, but that was the only reason why I did not do an emergency condemnation. It was because Mr. Sohala has been paying for Moon Security to monitor the hallways, the corridors.
And those then would also give a trouble indication should a smoke detector be removed if that's a monitored alarm system.
Corridor.
The corridor. The ones in the rooms, even though they may be hardwired, are actually smoke alarms, single station room alarms, correct?
Battery
Operated, either way.
Some are
Some
kind of
either
hardwired,
hard
yes.
or
Yes.
battery. Okay, so then my real concern is the fire and life safety issues that were noted in the letter of March 4 that were in red, and also then subsequently the letter of March 10th.
Right.
Those things really concern me. I appreciate your argument about homeless,
Yeah.
but when you have serious life safety issues, the other alternative is death.
Understood.
And so,
yeah. I think we've addressed that, though, that we have replaced all of the carbon monoxide and smoke detectors, right? So that's, just to make sure that's clear. That, right, Mo?
Yeah, in the hallways is connected direct to the more security. If any smoke detector get fired,
Yeah.
then you start total in one security. Right?
What about the rooms?
Rooms don't.
But they all have a smoke
They
detector,
all have a smoke detector.
and they're all working and operational.
When I was here, all the smoke detectors,
Yeah.
we usually check, like if people let us in, if they say the smoke detector is like a died, it start beeping.
Mm-hmm.
Right, that way we know they need a battery.
Mm-hmm.
But if the guest or say tenant in the room, they take it off from the room and they start cooking, then it's really bad for us.
Right.
But I don't know what we can do about that. That's the point,
Yeah.
right? I mean,
Oh,
I remember
yeah.
when I was in college, right? My roommate undid the smoke detectors because they were beeping, right? And
Yeah,
so
no, I
you know,
understand that.
And so I realized later, I'm like, that's probably not wise. So we
Yeah.
probably shouldn't do that. So,
Yeah.
but if there's any particular remedial action specifically that is a life safety issue that you guys feel like we need to do, like I said, we'll man a person at the back door. We'll board up the rooms that are unoccupied. We've already, I think, covered the life safety issues with the fire. I think we've done all that we can do on that issue. And so, again, appreciate your time. I know it's getting late, so I'll be quiet now.
So, city, Ms. Johnson, what can they do? Is there anything, are we beyond that now, or do you have the list, or do you need to go back there? You'd have to see?
I have several lists. I do have some clarifications. I mean, I understand the lists are long and there's a lot of things on it. The red life safety issues is what we were really focusing on. That and this list of chronic nuisance criminal activity. This notice is accumulation of all of that together and the effects that it's having on that portion of our community. It's really affecting it. Mm-hmm. Again, we have meth coming in and out of there, heroin, firearms, people with DOC escape warrants, felony warrants, people that have multiple warrants. I was standing there one day and a lady tried to come through the office and Jerry, the manager, was going to let her go. But the officer I was with said, no, if you're not visiting somebody, you need to leave. So she left and came to that east end door that's damaged. And when we go to that side, she is out there and we have two officers that had been watching the building because of activity. She ended up having, I think, 6 warrants for arrest, and she was trying to come in the other building. So this is a constant problem there. Again, we have a daycare right up the street, a block away, and one going in across the street. So I understand that there's things that are trying to be done right now and that the building is under sale. But like you said, that's a contingency. What guarantee does the city have that if it doesn't sell, that we're not going to be right back in the same spot?
So to answer that, and again, as far as the issues with police calls and all we can do is evict everybody from the building, right? So whether this property sells to this particular buyer, right? Let's just say this one falls through. He's going to sell it to the next guy. It doesn't make a difference as far as the eviction process goes. As long as the proclamation says, as long as you're planning to sell the property, you can give a 60-day notice to evict. So it really, truly doesn't matter if this particular sale fell apart. He would sell it to somebody else. It doesn't stop them from evicting. So again,
As long as he finds a buyer, right?
it doesn't matter. You can, as long as he's at it, he doesn't even have to have it listed. The proclamation is kind of silly on that point, because what's happening is a lot of landlords that have tenants that aren't paying rent are just giving 60-day notices saying that they're selling the property. The DA's office doesn't really, or not the DA, the AG's office doesn't really do anything about it. But the difference here is that he actually is planning to sell the property. So I think he can, in good faith and in good conscience, give those notices and jump through those hoops. I will say that, it's very possible that the governor could lift this moratorium. I mean, we've heard talk from other attorneys that work for Northwest Justice Project that maybe he's going to lift it sooner. So I don't know. But be that what it may, we've already given the 60-day notices, so even if it's lifted, we're still stuck with a 60-day notice. And I think that's fair to the tenant or the occupants to let them have some time to find a place.
I know you said earlier, what can you do? From what I'm understanding, there's a daycare across the street. I'm concerned, and I'm looking at all of the nuisance. So you said something about putting a security guy out on one of the doors. Maybe that's what you guys ought to do.
Okay.
If you're wanting to have some lenience.
Like a full-time security guard.
Full-time, 24/7.
At least until the door's in place. Because once the door's in place, nobody can come in or out. I mean, they can't come in, and if they go out, it's going to set off an alarm. But I think that is a reasonable request. We could do that. Is that okay?
I know.
Mohinder, we put a security person or somebody.
Well, it'll be installed by next Wednesday or Thursday.
True, but until then.
We can't find a security guy right away.
Well, I think you're going to have to. You have to find somebody.
No, but we got 24 hours front desk now.
Right, but the problem is that there's in the back.
But back, maybe I can put in a few days, order one push bar, make it same door. Maybe I could do that, I don't know.
You can go to any construction company or box store or even a door company. We've got quite a few of them here in Pasco, and you get a construction core. It's an ugly door, but it's...
Or a construction door?
Yeah, it's a construction door. It's they call it a construction core, but it's ugly, but it's strong, and won't get kicked in. At least until your new one comes in.
I was gonna say we would love to just lock the thing, but we can't because it's a safety issue, right?
Yeah.
There's got to be.
Basically, you're just going to buy a cheap door for right now.
Yeah.
No, but I already ordered the door. I can't cancel that. They're going to install it.
Agreed. This is just a temporary fix. This is just a cheap, ugly door.
Still need
So
the new
when
one.
is the contractor coming to install the door?
He said next Wednesday or Thursday.
Next Wednesday? You mean this Wednesday?
No, next week.
Yeah. Okay.
Today's Thursday.
Right. So yeah. Okay. So like a week from today, it will be in.
Yeah, less than a week, nothing Wednesday or Thursday.
So in the meantime, I think what they're asking is we need to have somebody, you either have a temporary door in there or you need to have somebody watching
They
that.
still break the frame.
Okay.
Or
Still
you,
break the frame. Before it was like a little window in there. And they put the window in. No
Yeah.
window.
Okay.
My other problem is, I know that you're asking for a waiver or some kind of leniency on the $25,000.
Yes.
And I've been sitting on the board for quite a while, and this is not the first time that he's shown up in front of the board. So it's been the same problem over and over and over. And I know last time he was here, he also told us that they were selling the building, and now it's okay. It's going to be sold hopefully in 60 days, but that's not a guarantee either. So we definitely need to start addressing all of those issues.
Okay.
Every time I see him, it's the same thing, over and over.
Understood. Well, that's what we're asking. Oh, go ahead.
All right, thank you, folks, appreciate it.
Thank you.
There being no further evidence to be presented, I determine the record complete. The hearing is now closed. No additional evidence will be permitted. The board will now discuss the charges, facts, and evidence presented, and we will render our decision. First off, do we agree by preponderance of the evidence the city has proven that a violation of the Pasco Municipal Code has occurred? And may I have a motion one way or the other, please?
I move that the board, having heard the case and the facts presented, and by preponderance of the evidence presented, find that the respondent is in violation of the Pasco Municipal Code.
Is there a second?
Second.
It's been moved and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Thoughts?
Yes, sir.
You can't ask him any more questions. We're done. To the fine?
Mr. Chair, I can ask, or
Oh,
I can
okay.
answer, since I'm the secretary, on fines.
Oh, okay,
Yes.
okay,
Just nothing more about the case.
okay.
The 25,000 that is being assessed now, are we limited to that? Or can we increase that?
That's a maximum daily penalty.
Mary?
Well, I totally understand the hardship we're going through. I totally do. Maybe if we put it in abeyance, and if that property doesn't sell, then he'll have to pay for it. I don't have a problem putting it in abeyance. And then if it comes back,
Well, it would have to be worded in such a way that everything will have to be corrected. And so they're saying it's the end of May? Okay, so we have the end of May. And then,
Mr. Chairman, I also, if I understood correctly from the attorney, they've issued the eviction notice because the property is for sale.
right,
60-day eviction notice. So irregardless, if this sale falls through, the eviction notices are still in effect and the property would be vacated in 60 days, if I understood correctly. It's that 60-day eviction isn't contingent upon the sale of the property.
okay.
So
Well, here, excellent point, Dwayne, I appreciate that. My thought is that, okay, that I don't want to give them much time beyond the 60 days to finish everything. I'm talking the rooms and everything, because honestly, I want to fine him the $25,000. Okay, that's what I want to do. But on the other hand, I also understand what Mr. Homer said and Mr. Saltz had said. So, but because we've been down this road before, and I think we're going to be here again, I'm not going to extend, maybe 10 days beyond the 60 days. And that would be, at 60 days, if people are out there and those rooms better be done the way they're supposed to be done.
Yeah.
If I'm going to hold it in abeyance, that's what's going to have to be for me. I can't,
I'm not sure if I'm allowed to make a comment.
no. It's okay. What do you guys think?
Well, that's my thought, is to give them the 60 days. But if the rooms aren't brought into compliance and everything fixed and the tenants removed, they pay the 25,000.
So, but we have to give some time to actually fix the rooms then.
yes, he's gonna need
A
No,
couple
he's got-
weeks.
30 days.
He's got 60 days.
Oh, he's
Well,
got
no,
to
because he
60
can't get into a lot of those rooms right now.
Yeah.
So after they leave, they get 30 days, plus by the time they get the letter, that's gonna give them another 2 weeks. So in reality, he's gonna end up with
Okay.
about 40 extra days, 60 plus 40, so.
But may I offer this? I appreciate, I haven't been here for all those other issues, and I appreciate where you're coming from. But the fact of the matter would be, is if the building is vacant with no occupants in it whatsoever, I would submit there is no life safety hazard at that point. And those issues being repaired, not repaired, whatever,
It won't matter.
the building could not be occupied until such time as those violations would be repaired, corrected. So if the building, if the residents, all the occupants, not just the tenants, but all occupants are out of the building in 60 days, is there still a threat to life? See what I'm saying?
Well,
And
the way I see it, people are breaking windows coming in, they are still gonna be coming in, even after 60 days are gone, because they're used to doing that.
then they're trespassing and can be criminally arrested.
Is there security going to be out there 24/7?
What do we do about the, okay, because you kind of heard the background and everything. So, look, if in 60 days it sold and everything was great and golden, and I'm okay with that. However, that's 50-50. And then in 60 days, it's going to be back here again. What I would still want the stuff fixed and repaired, because if he doesn't sell it, he's going to it needs to get reoccupied again. All those things need to be fixed.
That's my point. He can't.
Yeah.
There could be no occupancy
Exactly.
until all
But
of these are
there has
corrected.
to be some accountability at the end here,
Absolutely.
so that those repairs and those those other safety issues and everything else is fixed and brought up to code, so it can, it can be fixed, so we're not doing this again.
Correct.
So, are you suggesting that we would hold it in abeyance then, maybe a couple weeks beyond the 60 days? And if it's not all done by that, then we impose the penalty?
I would be comfortable with that.
I just think they need an incentive to, in the meantime, everything on the door, all these other things, painting while they're getting it all fixed up for the new tenants or whatever. And then if he sells it sooner, more power to him. But I think the 25,000 hanging over his head would be a very good incentive to make him want to get that done in that short period of time, knowing that's coming. Because this will be the last time. What do you guys think?
Put in advance for
Called 70 days.
75?
70. And it takes 10 days to get the notice anyway.
I'm not trying to interrupt your discussions. I just want to make a clarification. I'm not
Okay.
trying to make an argument.
Yeah.
The 60 days is the notice period when they're supposed to be out.
Right.
You can't make them go out during that 60-day period. So if we get to this, like for instance, it's very possible or even likely that there still will be occupants that are there at the end of the 60 days. At that point, we would then have to, that's the soonest we could start an actual court eviction to get them out. And that could take another 20, 30, whatever days, right, to go through the eviction process. So I think we're gonna get most of them out, but I didn't wanna make it clear that I can't guarantee that we're gonna have, like I said, there's already been a few that have left. I know one left again today, another one left today. But we did this for Loyalty Inn previously, if you remember, on another building. And when we gave all those notices, most all of them left, and there were still a few that we had to actually go to court and evict. So I just want to make that
Okay.
clear.
All right. Okay.
Let me ask you, Chairman, just among us, hearing the clarification. Can we put the $25,000 in abeyance for, say, 70 days, whatever? We know 60 days is when the eviction is supposed to be taken, and we understand we can have some issues there. However, if at 60 days in the eviction and there's still residents within the building or tenants or whatever, that all of the fire safety issues, the red lettered issues in here have not been corrected, the $25,000 fine is imposed.
So they need to get in there and check that stuff in the rooms that would still be occupied and all that. That's what we're talking about. Okay, yeah. What do you think of that, Mary? Did you understand that?
I did, but I'm still
Processing it?
processing it it's still going back to what I was saying, let's give them the 75 days.
Well, that's kind of where we're at then. Yeah.
Exactly.
And that will give them the extra time to get them out.
Because if he has 4 or 5 tenants that don't want to get out, I'm sure if he offered them a financial incentive, it would be less than the 25,000 they'd get out.
Yeah, there's lots of possibilities there. Okay. So if I understand, what we'll do is we would give them 75 days. And at 75 days, all the corrections on all the safety stuff has to be completed, okay, at 75 days from notice, or the $25,000 fine will be imposed.
But,
That's what we're
but,
talking
but
about.
then I have a question is, he does that, what's to keep him to start re-renting again?
Well, if everything's fixed and done the way it should,
Well, you're just saying just the safety things. So why don't we say that all the violations have to be corrected in 75 days?
Well, yeah, because we need to get rid
Okay.
of all of that.
Right, need to get
Yeah.
rid of the infestation.
okay, so everything needs to get corrected.
Right.
Okay, because what I would do is I would, in the meantime here, and look, he's a smart man.
Right.
Clear, okay? So what you do, it's not hard to plan ahead and say, okay, well, we need this many doors, and you got them sitting there waiting when they're out of there, right? That's not a hard thing. So I could go with the 75. Do you want to make the motion, Mary?
All right, so 75 days.
Right.
In advance, and all the corrections have to be corrected.
Or we'll impose the 25. Okay.
And it was a repeated violation? No, okay. I move a $25,000 penalty be imposed but held in abeyance for a period of 75 days from this date and dismissed if every violation has been corrected that is up on the board and the email that he received. So everything has to be corrected. Otherwise, the $25,000 will have to be paid.
Is there a second?
Second.
All right. It's been moved and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. So it'll be 75 days from the time you get the notice. So it's about 10 days beyond that, generally speaking. But we want everything corrected.
And just to clarify that, the nuisance activity or the police coming and going and all that stuff?
If the rooms are empty and there's still people going in and out of there, it's on him. Okay.
We will do our best to get everybody.
Okay. All right.
All we can do.
Yeah. Thank you. We appreciate it.
Thank you, guys.
Yeah, you bet.
Thank you, everybody.
Yep.
Have a good night.
Yep.
Stay late for us. I'm sorry.
No problem.
Okay, no worries.
Okay. Do we
Mr.
have
Chair,
any?
That's all we have tonight.
Okay. Do we have any amendments or dismissals to the resolution?
No, sir.
We're good. Who wants to make a motion on the resolution, please?
I move that the board approve resolution 04/2021 as amended, finding that code violations have been corrected and may be dismissed, deferring action on certain cases until proper notification is made, accepting voluntary correction agreements, and assessing penalties and imposing timeframes on certain cases.
Is there a second?
I second.
It's been moved and seconded to accept the resolution as amended. Any further discussion? All those in favor say aye.
Aye.
Aye. Any opposed? The motion carries. Do we have a report from staff tonight?
No, sir.
Any other business?
No, sir.
There being no further business before the Pasco Code Enforcement Board, this meeting is declared adjourned at 9:45.